My lord, I arrived and the court with a fighting mood.
Very well.
But your lordship's officer, my lord, would be down. That matter was supposed to appear today. Unfortunately, not appearing. I have arranged everything.
Which one? Which one?
That we are arguing.
That party. Aditya.
Oh, yes.
Supplementary list.
Yes.
He is in a mood to.
So
No.
Fighting goes.
I won't let you down.
Fight.
I won't let you down. You have the room to fight. Don't worry.
Grateful to buy.
I have already filed a paper. Everything.
Inclusion of second appeal. Have you served?
I have said, but what that the respondent has is not residing there, has put law, and we are not in a position to know where she is. Although I sent it
by post. What about her lawyer?
His lawyer, there is no lawyer. She has not appointed a lawyer. And also the lower court lawyer, I contacted him, but he will not accept. This is the return of that.
What about notice to appeal? It was also not served.
Notice to appeal. The entire paperwork order was sent, but this has been
returned. I need to Aditya for it. Up to 28. You are the defendant appellant.
I am the
Tenant.
Yes.
Very well. What I attach
the last occasion, my lord,
you haven't served.
No, I have served.
You have served.
The last occasion, I have mentioned the matter yesterday. My lord has accepted my mentioning, but the department told me that there are 8 matters and all matters are analogous. It is not possible for us to put only 2 matters. But I am appearing only in respect of the 2 matter is concerned. The stay has been granted by this honorable court since the year 2013. The matter has been stayed. We could not proceed with our suit.
Revision or appeal?
Revision, my lord. But 8 matters are interconnected to each other. I am appearing only in respect of 2 matters.
Petitioners.
The opposite party, man. But the petitioner has this honorable court.
It cannot be segregated.
No, but there is no other because I am appearing only in respect of 2 matter. In regard to the other matter is concerned,
you have to notify the others.
I do not know who is appearing for the in respect of other
cases. Go
cases.
through the record, you will get to know.
Great.
Lordship, may I be permitted to mention one application? Lordship, that application.
No, unless you serve.
Grateful.
Lordship,
you serve and come back.
Lordship, that application where Commissioner of Katwa Municipality and Councillor that matter, Lordship, I have amended I have put out an application for amendment of cost title, Lordship. Kindly.
It is to be included in the.
Yes, included.
It's not running in the list.
No.
I didn't hear into Aditya.
My lord, may I permitted to mention, my lord?
Yes.
I'm mentioning for inclusion in the list, my lord.
If it is served.
My lord, it's a compromise application in connection with this civil revision. It is
civil appeal.
Civil revision. It is pending since 2001, my lord.
Civil revision or civil appeal?
Civil revision, my lord.
Revision.
My lord, may be permitted to mention an application in connection with second appeal, my lord. Application for substitution. I have already served, my lord.
Have you permitted to
Yes,
mention
my lord.
Item number 4, my lord. But I am paying for 2 days accommodation, my lord.
Why?
Yes, my lord.
Where is your friend?
But I have already served notice. On the last occasion, your lordship was pleased
notice of adjournment.
No.
Then,
On the last occasion, your lordship was pleased to ask me to serve a notice
Hmm.
upon the respondents, non-appearing respondents. I have already served.
Bank of Baroda.
Baroda and others, my lord. I have already served, my lord. But only 2 days accommodation I am taking. Let it be taken up on Thursday, my lord.
না, এটা কেন? আজকে তো আছে। ঠিক আছে, কি অসুবিধা? হ্যাঁ, দিয়ে দিন। Wait, let me see.
Lordship.
দেখি দিন তো। আজ তো কল দিন।
Item number one, lordship.
What
and
correction?
Correction, lordship, there's a typographical error, lordship.
You should learn to ignore certain things in life.
Lordship, it is,
Huh? Typographical error. Yes, what is that?
lordship, in the second paragraph of the order, the year is mentioned in 2002.
2002
Yes, lordship,
instead of
2022.
2022.
Paragraph number 2.
So petitioner died sometime in the year 2022.
Lordship. And the same in paragraph number 3.
3. Okay.
And the next paragraph, beginning with subsequently on 16th March
এটা
2023.
কি করেছে?
And lordship, the next paragraph, under such circumstances, lordship, this I do not find any reason, lordship, there.
Yes, 2002.
And lordship, one more thing, lordship, I'm reading out. Under such circumstances, I do not find any reason, lordship, here a not should be there. Lordship, if the meaning. Thereafter, my lord, it was all right.
এই দিদি, you have set back the hand of clock for 20 years. লিখুন। Inadvertently, in the order dated 26th of June 2023, the date of death of the petitioner Ajit Mondal
Lordship,
has been recorded as a date now, year of death of Mr. Ajit Mondal, the petitioner, as 2002 instead of 2022. This typographical error is appearing in paragraph 2 and paragraph 3 of the order. In paragraph 4, in place of 16th March 2023, it is written as 16th March 2003. Instead of 2023, it should be 16th March 2023. in paragraph 5 again, the year 2002 should be 2022. And the sentence at the beginning of the paragraph, inverted comma, under such circumstances, comma, I do not find any reason to act upon the submission, in inverted comma, does not carry any sense unless the word not is inserted. The order dated 26 June 2023 be rectified by removing the typographical mistakes as indicated herein above. Henceforth, order dated 26 June 2023 should be read conjointly with the order, with this order.
Grateful.
Yes.
Item
Where
number,
is Mr. Chatterjee?
yes, sir, learned advocate Mr. Chatterjee is in court number 5. So paying for a short pass,
He has requested me to keep it at 12 o'clock.
12 o'clock.
12 o'clock.
Grateful,
Pass over till 12.
grateful, my lord.
Always.
Then, Senator.
My lord, in this matter, I am appearing for the, my lord, defendant, my lord, petitioner, my lord. My lord, I have an instruction, my lord. A talk of settlement is going on, my lord. Give me some time, my lord.
You have been given 18 years. What else? What? Wow. How much time is required? 18 years plus?
My lord, at least 3 weeks my time given. My
3 weeks.
My lord.
I don't understand 3 weeks. Just tell me the specific date. The petitioner was absolutely reluctant. Give me a date. The 17-2 application.
17.
Challenging that you have come before this court.
My lord.
There is no order of stay.
Yes.
And the suit is pending before the trial court. Give a date.
3 weeks, my lord.
I don't understand weeks. Give me a specific date when I shall be free to dispose of the matter. In your presence or in your absence, whatever. Ashun, madam.
August 22nd.
22nd August. 3 weeks. No, your arithmetic was very poor in school days. Yes. Learned counsel for the petitioner, Mr. What is your good name? Gautam Das is seeking an accommodation on the ground that a talk of settlement is going on.
My lord.
On the ground that a talk of settlement is going on. Stop. The matter is pending for 18 years. As prayed for by Mr. Das, let the matter be listed on 22nd of August under the heading for orders. If on the adjourned date, parties are not represented, the matter shall be disposed of on merit based on materials available with the record in the light of the mandate of Honorable Supreme Court given in the case of Robin Thapa. Bakita mone ache Robin Thapa? Grateful man. Yes. Interim order. It died long back. There is no substitution. Interim order is no longer there. Yes, my lord. When? Adegi record ta. When it was passed?
My lord, it was initially passed, my lord, passed.
For how many days?
2006, 1st February 2006,
For how many days?
till the disposal.
Till the disposal. My God. You go and purchase ticket, lottery ticket. Where is that? No.
1st February 2006, passed, my lord, Supreme and Supreme Court.
Interim order shall inure. Madam, একটা line লিখে দিন. This is absolutely interim order shall inure till 22nd of August. The order dated 1/2/2006 is modified. Then what was the use of mentioning that when the interim order was there till disposal of the application? Now it will not extend it beyond. Yes.
My lord, I was waiting for
Four, you want to come back?
Thursday.
Thursday. এই এটাকে বৃহস্পতিবারে রেখে দিন তো।
I'm grateful, lord.
But inform the respondent.
But I have served notices, my lord.
They haven't turned up.
Two have returned,
Very
and
good.
one have received, my lord. Bank of Baroda has received. But I have also prepared an affidavit of service. I'll file on the next.
Okay, okay.
I'm grateful, lord.
Today is 27th, no, it will appear.
I'm grateful.
And পরেরটা দিন।
Opposite party,
Opposite party.
no matter,
What is the suit for?
but I'll be very candid, my lord, that we could not trace out the brief, but my lord, what I recapitulate, because even I did this matter long back, there was a suit filed before the trial court. If I'm right, my lord, we took out an application under section 5 and 8 of the Arbitration and Conciliation Act, saying that there was a specific arbitration clause. ঠিক আছে, তাহলে বলো,
Mr. Rai, Parthapratim Rai.
What
So the
I'm
link
saying,
is coming
my
from
lord, will
proceeding number
kindly
90.
kindly appreciate, my lord, will keep it. পরশুদিন রেখে দাও, আমার কাছে brief আছে। The only point, my lord, involved is 5 and 8. We took out an application under section 5 and 8 before the learned trial court, before filing our first statement, what 5 says. Learned trial court was pleased to stay the suit and say that matter should be decided by arbitration. That order is under challenge before my lord. And since then, the matter is pending. I suppose it was filed in 2015. 14 now, they are sued. 14
Day
to
after
24.
tomorrow.
Well, day after tomorrow, only that point only. Yes.
Inform Mr. Roy.
Yes, Mr. Roy is rushing from Kotum.
Madam, একটা কাজ, এটা order, এই আদিত্য, এটাও 27 ফিক্স করে দিন তো। ওর কোনো অর্ডার দিতে হবে, ফিক্স এটা।
My lord, it will be pleasure of my lord to keep it on Friday. If my lord, I
Friday,
yes, my lord, because
Friday at 3:30.
my lord, no, my lord, 3:30. My lord, any time.
Okay,
my lord,
okay,
because
okay,
not
you
my-
come back. On 28th, এটা 28 তারিখ রাখুন।
I'm grateful. My lord,
28, yes, 28 Friday.
I'm grateful.
You're on the opposite party.
Hmm.
Milord, on the last occasion when the matter was taken up, Milord,
Hmm.
there was a direction, Milord, to serve copy to notify, Milord, other side, the matter will be taken up.
Hmm.
You're on the opposite party.
Lordship. So, Milord, may I file the affidavit of service, which was my Lord direction.
I don't
My Lord, here the issue is very short. It's a matter coming from the consumer court. Now,
Hmm.
Milord, consumer, Milord, Milord claims to be consumer, the petitioner therein.
Hmm.
Milord, we said that he is not a consumer, be that as it may.
When
Milord,
it is appellable order,
Section
why
19,
before
my
this
lord.
court?
not appellable, Milord. We preferred appeal.
Yes.
We preferred appeal, and thereafter, Milord, no, there is no provision for second appeal.
No, National Commission is there.
National Commission is there, but say, Milord, provision for the there is scope for Milord revision.
No, my
Now,
lord.
Milord,
No, you
Aram
can,
Bolini
please, don't interrupt. This is not,
only Milord, one option for appeal is there under Consumer Protection Act. But this was a complaint under Section 12. Then, Milord, there is a provision, Milord, for appeal under Section 15. That we have done. Milord, basic point was taken that he is not a consumer. Consumer court is meant for the consumers only. Now, who is consumer? If that is any matter takes up by any court without jurisdiction, then question comes, Milord, whether I will appeal or Milord revision, I will prefer revision, or I will not come to this
Mr.
honorable
Nayak,
High Court.
subject to correction, if
My-
there is some statutory provision for statutory appeal.
No, appeal is not there. I am saying, Milord, there is no scope for Milord second or third appeal. Only one appeal, Milord, scope is there.
You mean to
That has
say
been exhausted. Under
No.
Section 15, we have exhausted.
National Forum doesn't have the,
No, consumer forum, then Milord, the State Commission is the appeal. So, Milord, we have preferred appeal in the State Commission. State Commission, Milord, was reluctant to consider our point. Therefore, Milord, they allowed or Milord, they rejected our Milord appeal, and Milord, they upheld the order of the Milord District Forum. Now, the question comes, if any matter takes up by any court without jurisdiction. in
that is fine.
Lordship.
That is fine. But my question is
No, that is not there. No provision for Milord second appeal.
very
Had
well.
it been there, I will withdraw this matter.
Very well.
My learned says, Lord, there is, this is not known to me. If my learned is satisfied, then Lord. Now, the question,
Go through, my lord, Section 19 of Consumer Protection Act, my lord. My lord, may I read, my lord?
Yes.
Any person aggrieved by an order made by the State Commission in exercise of its power conferred by subclause 1 of clause A of Section 17 may prefer an appeal against such order to the National Commission within a period of 30 days from the date of the order in such form and manner as may be prescribed, provided that National Commission may entertain an appeal after expiry of state period of 30 days if it is satisfied that there is a sufficient cause for not filing it within that period, provided further that no appeal by a person who is required to be pay any amount in terms of an order of State Commission shall be entertained by the National Commission unless the appellant has deposited in the prescribed manner 50% of the amount or rupees 35,000, whichever is less. My lord, in this case, my lord, State Commission passed order, my lord. My lord,
What is section 17? Section 19 is subject to the provision of section 17.
No,
What is that?
jurisdiction of State Commission, my lord.
Yes.
Subject
direct.
Subject to the other provision of this act, the State Commission shall have jurisdiction, complaint where the value of goods or service and compensation, if any, claimed, but does not exceed rupees 1 crore. And second, my lord, appeals against order of any district forum.
Yes. Appeal,
Appeals against order of any district forum within the state.
fine.
Okay.
This is a complaint Milord under Section 11 and 12 originally. Then Milord against the Section 15. Section 15 you read. Section 15 is the first appeal and
Before
the State Commission.
State Commission.
Similarly, Milord 17 is the direct Milord complaint before the State Commission. Against that Milord first appeal, National Commission in 19, what may it is not a case where directly moved before the State Commission because it was not a case, it did not, the pecuniary jurisdiction did not permit.
Be that as it may, that was not the issue before any of the court. Now the issue is very simple, that against the order of the district forum under section 11 and 12,
Hmm.
Milord, appeal was preferred under section 15.
Now, Mr. Naik,
Lords.
according to you, state forum, state commission, consumers fail to exercise jurisdiction.
Lordship.
Otherwise, 227 wouldn't have arisen.
Yes, yes.
What is that?
Only issue is this, Milord, a person who was aggrieved before the Milord forum, his contention was this, that he was not getting electricity. That was the issue. Now, Milord, consumer, who will be consumer, Milord, there are two definitions. One in Consumer Protection Act and another is Milord Electricity Act. Milord, Consumer Protection Act says that who has purchased a goods or who hired a service, he can be treated as a consumer. A person who is dreaming that he might get electricity, and there are some other unforeseen problem, because there are some private persons who were also added to the complaint. They opposed us. That's a matter related to merit. Certainly, I will not trouble your lordship by referring certain observations on merit. I am simply saying that our question was our submission on a point was very simple, that he was not a consumer. A person who says that I am not getting electricity, he cannot be termed as a consumer.
You did not give them connection service.
No, that in the meantime, they have got it.
After filing this revisional.
Be that as it may, that time his demands,
No, at that point of time,
he did not get electricity.
so he was not consumer per se under WBSEDCL.
Not
That is-
consumer, we say.
That is what you were contending.
Yes. And I say, section 215 of the Electricity Act says that who will be treated as a consumer, lordship. It is said that who is connected.
Now there is one, yes. Now, how does it?
It is not dealt with at all.
No, fine, but I cannot correct the wrong committed, if any, by the learned.
I'm not saying, even this, they have said you give connection, at the same time you give compensation also. Now, Milord, so far as reliefs are concerned, either the complaint should be quashed if our contents is upheld, and another point is also there, I will argue on this, that give connection and also at the same time give Milord compensation, because why he delayed the matter. For our delay, now Milord, there are very, very cause and reason why delay was also committed. Because the private persons, they opposed us. According to law, they are to arrange for free access.
How does it affect the exercise of jurisdiction?
Because he is not a consumer. But I say, I again go to the root of the our contention. Our contention basically is this: it cannot be a consumer's complaint. He cannot be a consumer. Why he is not a consumer? If a person is not a consumer, then his case cannot be entertained by consumer forum. He is not a consumer, therefore that case was taken up. And on merit it is decided. He could have approached the civil court. He could have approached the Honorable High Court also. There is also certain bars and all that I am not on that. Now, before the consumer court, if a person is not a consumer,
on the date of filing of the case, he was not a consumer.
Even till today, definition has not been changed.
No, I already consumer.
Now he, as on date, you were serving.
He is saying that he is getting. I have also confirmed it, he has got connection.
So as of now, he is your consumer.
He is a consumer.
When the petition of complaint was filed, he was not.
He was not. Therefore, he was not likely to get two reliefs: give connection, take connection, and also compensation. And for compensation, some cogent reason has to be given. That also again goes to the merit of the case. I am not on that. I say on the date of filing of the case, if a person is not a consumer, then how it can come?
Point.
No. I'm not the appellate authority.
No,
the question being raised by Mr. Naik is very fundamental. Since you were not given connection by WBSEDCL, so you cannot be treated as consumer under the Electricity Act or Consumer Protection Act.
My application before the district forum, my lord. District forum decided, my lord.
Sir, what Mr. Naik is driving at, since you were not a consumer, learned trial court committed jurisdictional error in granting the relief.
My lord,
You
my
follow
only
what
question
he is
is
saying,
that
if I am not wrong.
My only question is that, my lord, if I wrong, my lord, I file the application before the district court. They applied before the civil court, my lord. They papered first appeal, my lord, in state commission.
So, please try to understand. Since you were not a consumer, trial court had no jurisdiction to grant compensation or relief to you. It's a consumer forum.
At that time, my lord, company, my lord, papered civil division application against the district forum's order, my lord. Why they papered first appeal, my lord? Unnecessary
How
delay.
does it matter?
Unnecessary delay, my lord.
Unnecessary delay.
My lord,
No, what is your answer to this fact that you were not the consumer when you preferred the application? That fact strikes at the root of the case.
I got a connection, my lord, after filing of this.
After filing of the suit. So, learned trial court committed jurisdictional error considering you as consumer.
They favored first appeal. They
Take down.
moved to this civil court, my lord. Only compensation has been decided, my lord. 2009 to 2023, my lord.
Would you like to come back or should I dispose of the petition?
I'm actually, my lord, I not case of my fee, my lord, trying to direct.
I cannot direct you. Request your senior friend, he will provide.
I don't have the brief also. I have collected the orders.
You want to come back on the adjourned date?
Yes.
Have you realized what is the point?
Yes.
Very well. What is your good name?
Chandranath Sarkar.
Chandranath Sarkar. Mr. Chandranath Sarkar, learned counsel for the opposite party, is seeking an accommodation.
আমার কাছে কপি নিতে কপি দিতে হবে অর্ডার দুটো কালেক্ট অর্ডার দুটো তুলে নেবে এখান থেকে
অর্ডার দুটো আমার কাছে আছে
আচ্ছা ওই অর্ডার দুটোই নিয়ে মামলা করছে
Heard Mr. Nayak representing the petitioner. Let the matter be listed on 31st of July. Enough time, do your research work and come back to.
Next Monday.
But kindly, admit online. I have submitted affidavit of service.
Affidavit of service is taken on.
Partial to my lord's order.
Affidavit of service is taken on record. Yes.
ওই অর্ডারের কপি নেই আমার কাছে দেখো না এটা দেখি দুটো অর্ডারের কপি নিয়ে আর্গুমেন্ট করছে
আমি দুটো অর্ডার করছি আমার কাছে
ব্রিফ হারিয়ে গেছে
এইটা
এই কনজিউমার ফোরাম কনজিউমার প্রোটেকশন অ্যাক্ট একটা আনাবেন তো
it clearly says not who hired or who has got.
Anyway, there is no harm in reading the provisions. You come back on 31st. In the meantime, book will come. I will also have the
always a
pleasure
prayer
to
for us to come. Only distance is not the barrier.
look the silver lining. It keeps you fit.
But we can't reach. That's true. We can take our morning exercise
You
also.
don't need any TMT, nothing.
Nothing.
Only to and fro.
That is
You can reduce your calories. Yes.
2-3 matters are going on, not even then I am.
Perhaps this health issue is in the mind of the administration, so that all of you can stay
all these
fit.
courts could be arranged there in one place, Lord. That is congenial and also helpful for every lawyer.
I am not authorized even to lend my ears to such discussion.
Lords.
Then am I need to issue any lookout notice? No, just catch hold of him and bring him.
My lord,
Come back,
He will come back at
short time.
within short time. Very well. We can wait.
He told me, and we'll submit.
Is this
my lord, I have to pray for leave first to appear before your lordship in robes.
very well? Let Mr. Basu come.
Lordship,
You are appearing in person.
Lordship, for the petitioner, my lord,
I am
the
also
only-
person.
in person with Mr. Shop.
Then,
My lord, let him address the court.
Okay, no.
Let him address the court.
Person maybe.
no,
This
if
is
you
beyond
want to,
decorum.
No.
This is beyond decorum. I will not object to the Passover. I am not objecting to the Passover right now. My lord, this is with regard to my succession, which an opposition was supposed to be filed and served. That opposition has not
let
come.
Mr. Vasu come.
My lord, I'm not submitting on that at all. On that at all. On that at all. My lord, if at all, the succession, the point can be kept open for the final hearing also.
Let Mr. Basu come, we'll take up
My
and
lord, at
consider.
12 o'clock.
Inform him at 12. You are his friend, just give him a call. Fix the time and
He's much senior.
so what?
A learned junior friend I can.
Friend after all. Then
In this matter, I am appearing on behalf of the opposite party. Today, I have received the brief as well as the wakalatnam. Kindly provide me
Why-
1 week time.
why did your client take 9 years to brief you?
Today, I have received it, madam.
No, that's fine. You know the matter is pending for last 9 years.
Now, my lord, just now I have seen that it's on 2014 matter.
Just now you have seen.
Just now. In the morning, I have received it and wakalatnam still I haven't done.
So what am I to do now?
Only 1 week adjournment.
Only 1 week adjournment.
Only issue involved, my lord, here we are the WBCDCL, we are the petitioner lordship. This is also originated from Consumer Forum.
Okay.
Here
Then on the same date.
same date, sir.
On the same date means 31st of July.
Lordship.
Madam,
They are appearing, so my lord, I am.
what is your good name?
Shayantan Rokit.
Shantanu Rok.
Shayantan Rokit.
Shayantan Rokit. Mr. Shayantan Rokit, Learned Counsel, representing the opposite party, is seeking an accommodation. Heard Mr. Naik on behalf of the petitioner. Affidavit of service.
Lordship. Since they are appearing also, here was a little bit defect in my affidavit. Now it is also, it can be not ignored because he is appearing.
Very well.
Lordship, kindly consider and keep it on record.
Let the matter be listed on 31st of July. Affidavit of service be kept on with the record.
In fact, I could not submit the.
Anyway, since he is representing,
Everything.
Keep it, yes, madam.
It's not in true sense abuse of service because track record was grateful. So,
have you filed your wakalatnama?
I will file it. Today I will file it. In the early morning, I have received.
Before it gets afternoon, you just go and file it.
My clerk has gone to the department.
Okay. Document.
Item number 11. This is my application, my lord. Last occasion, my lord, 19th June, your lordship. Direct
Item number
11, my lord.
11.
Last occasion on 19th June.
You are for the petitioner.
Yes, my lord.
Petitioner state.
Yes, my petition state.
Yes.
Your lordship directed on last occasion, 19th June, directed the department to submit a report as to service of Tolobana notice upon the respondent number 226 and call for the lower court's report. And your lordship also directed to serve notice upon the respondents. I have served, my lord.
No. It's second appeal. LCR has been sent down to Learned Trial Court for certain corrections on 13th of June.
30th of June.
June. So we have to wait.
Adjourned for 2 weeks.
Ashwin to take 2 weeks. Let me see. Let me see.
Well,
Heard Mr.
Rizawul Hussain.
Hussain, learned counsel representing the appellant. The office report indicates that LCR has not yet been resent by the learned trial court. Stop. The report of process server is also awaited. Under such circumstances, matter is adjourned to appear on
9th August.
9th. Are you comfortable? Very well. On 9th of August 2023, the office is directed to, department is directed to inform the learned trial court that the LCR must reach by 3rd of August. Through email করে দিন। Inform the department, learned trial court through email. Yes.
Great, much obliged.
Well, start, why not, we can receive any CAN application. We can receive any CAN application. This or you can say not receive.
What is this application, Mr. Ghosh? CAN 3, 4, 7, 8.
We have taken note.
Why so many petitions?
Lord, your lordship can see the order passed by huh? Can. Can 7 is 6644. So
Can 7
You haven't served.
yes.
What location appear? Opposition has been filed.
Opposition file, my lord, I am getting a note from this, from the report and file the opposition. But you cannot, you have record, everybody opposition file, everybody services file. Cannot.
देखो तो सर्विस वेटिंग में तुम्हारा क्लिक तो
अरे उसको कॉपी दिए आज सिर्फ फाइल है।
This is your affidavit in opposition. You are the appellant.
Yeah.
You are the appellant. How could you prepare your opposition without
Take
going
note
to?
from the record and make.
Now, what's the issue?
No, my lord, I get.
Lord, this is our application. Lord.
No. What's the issue your friend is raising? Yes.
Issue, why not? It is a baseless application because amendment is not.
No, not on merit. What prompted you to say that copy was not served?
I just informed my lord. I just informed.
Yes. What is this CAN 8?
Lord,
Every second day you are filing an application.
Lord, your lordship kindly take can 7. It is our application, Lord.
CAN 7 good enough.
আগের দিন তো এটা তো পুলিশ অ্যাসিস্ট্যান্স কি করে হ্যাঁ ক্যান 7 এটা কত 6644 এটা কি
এখানে
এটা ক্যান 7 তো
CAN 7. Yes, Mr. Ghosh.
ক্যান 7 এটা
যেটা অ্যাপ্লিকেশন কোড আছে না এটা
নো ক্যান 7 কোনটা দাও
অ্যাপ্লিকেশন কোড আছে।
What is the suit for?
Suit for declaration and permanent
Record.
protection. There are two suit, my lord. One filed by me and that suit filed by the respondent.
So analogous trial is going on. Oh, it's second appeal.
Second.
yes
Oh,
Lord, kindly see Lord, we have filed
by a common judgment.
No. So the declaration, we succeed to the suit court order
No.
on behalf of. We only succeed the first appeal. First appeal.
তাহলে তোমরা লেখো না ফার্স্ট টেবিলে সাবমিট করলে এখানে লেখা না তোমরা ইউ আর দ্য অ্যাপেলেন্ট
আপনি ফার্স্ট appeal জিতেছেন।
তাই তো বলছি।
My lord,
You are the plaintiff.
I am not a plaintiff. He is a plaintiff.
You are the plaintiff. Plaintiff respondent.
Yes.
You are plaintiff respondent.
Respond.
And you are defendant,
I am a dependent.
appellant in both the matters.
Dependent, appellant, appellant, he is a appellant, first appeal, he.
Defendant, respondent, appellant in both the matters.
Yes.
What is it? One matters.
Huh?
One matter, 2 of 99 is a main suit, 2 of 99. But 2 of 99, you find the application, there are no 2 of 99, there are 2 of 1990. This is something wrong in this year. It's not related to the second application. 2 of 99.
Lord, kindly takes can 7, Lord.
Can
What
7
is our
of
prayer?
90.
Our prayer, Lord, to record amendment of the appeal as a whole.
Why?
Because, Lord, your Lordship kindly come to the order
Where is the plaint?
passed by the Honorable Justice.
Where
Lord,
is the copy of the plaint?
I am giving. Yes.
Where lies the commonality?
Lord, kindly, I am telling, Lord, kindly come to Lord the order passed by the Honorable Justice Vivek Choudhury in this matter.
No. Let me go through the plaint.
Yes.
You indicate where lies the commonality.
Yes.
My lord, there are several.
Wait. I will get back to you.
Lord, this
Copy of the plaint. I একটু দিন না এটা। জীবন বিহারী মাইতি। Bonobihari. Oh, Sri Bonobihari. Sri appears to be Jivan Bihari. What was the prayer before the trial court?
declaration and injunction. Mandatory injunction.
নালিশি ক তফসিল স্থানে বাদীর 16 আনা সত্য থাকা তাহাতে 1 নম্বর বিবাদীর তফসিল কমন প্যাসেজ ব্যতীত অন্য কোনো সত্য না থাকা প্রচারে ডিক্রি দেওয়া হোক। Fine. This gentleman was the sole plaintiff.
Yes, ma'am.
He died.
No.
Then
The Lord defendant, original defendants, one of the heirs who is appellant in this case has died. Appellant number 3. Before this honorable court. Appellant number 3,
Shilarani Shao.
Silarani Shao, who happens to one of the heir of Chandrasekhar Maiti. You know this Kanailal Maiti, defendant number 1. Defendant number 2 to defendant number 18, Lord, they have supported the plaintiff's case in the court below. Thereby joint written statement, therefore, Lord, their predecessor in interest filed one written statement and they contested also upon death of the original defendant number 1, Kanailal Maiti.
It was adopted.
Lord,
Did they adopt the written statement of their
Lord, that
predecessor?
is the, no separate written statement was filed. They adopted it, the father's written statement, Kanailal Maiti.
Yes.
Lord, upon death of said Shilarani Shao, they made an application before this honorable court for substitution of her heirs and legal responsibility after setting aside amendment upon condonation of delay. Lord, that application was rejected by the Honorable Justice Vivek Choudhury upon contested hearing. And Lord, thereafter against that order, they have not preferred any. They have not challenged that order. Therefore, my lord, the appeal has abated as a whole. গল্প নেই।
My lord, it is a appeal suit filed by the learned filed by the Bonobihari Maiti, and the first appeal, first suit order passed by the learned civil judge junior division on 2 of 1990 instead of 2 of 1990. It is wrongly represented in this order. Number 2, the appeal is 10 of 2015. It's not related to my case. 2 of 10 of 2000.
No. Second appeal 50 of 2017. Are you a party to that?
Huh?
Second appeal 50 of 2017.
50 of 27. I am a party.
You are party. Appellant.
Appeal.
And who is this lady? Sheila Rani Shah. She is the appellant number.
Is a daughter of
She is appellant number.
She is died in cancer in Kolkata. We can't get. My lord, kindly see the substitution petition. There we only date.
Have you gone through the petition filed by the respondent?
Huh?
Have you gone through the petition? Can 7?
Can 7?
What is their contention?
His contention is this appeal already appeared in a whole.
Yes. What is your response to that?
After the date of Kanailal Maiti.
No, sir. With the date of
paragraph number 14, my lord. Paragraph number 14.
Yes. Now, what about 15?
Paragraph 15.
Kanailal
Kanailal Maiti or when
Kanailal was survived by his legal heirs and successors. Sheila Rani Shah is one of them.
One of them.
Now, while she was representing as appellant,
One of them
died.
One of them.
One of the appellants. She is dead. You did not take out any application in time for her substitution.
Yes, my lord. Because we don't
By a judicial order, the appeal abated as against
no
Miss.
abated, not abated, only dismiss the application.
Application for? Application for?
Application for condonation of delay.
Condonation of delay.
Condonation of delay.
Thereby, what is the effect? If your petition under section 5 is not allowed, what's the fate of your application under order 22?
But my lord, right to sue is still survived the other respondent, other appellant. Right to sue.
According to the petitioners, because of the commonality, it should abate as a whole.
No, my lord.
Show me the law.
The right to sue. No abate by the party under section 22, rule 1.
Under order 22, not section, yes.
The date of the plaintiff or dependent shall not cause the suit to be abated if the right to sue is survived. This right to sue is still survived by law.
Then
my lord, the procedure for the procedure where one of the surviving plaintiff or dependent died on right to sue survive. Right to sue still survive, my lord. If right to sue survive, there are the several judgments passed by the Honorable Apex Court that if any right to survive is presented, other respondent is available, so appeal should continue. Even my lord, there is even my lord, kindly see in the page 4 here. That the honorable court please to consider the ordinary litigants on oath not to be denied an opportunity to have an least determine the merit unless he has the gross negligency and disability to
Your
implement.
application was dismissed,
Why
rejected
not given the
by the
other-
coordinate
other-
bench.
The appellant.
You show me, you show me authority that right to sue survives. There is no element of commonality, so it will not have it as a whole. Show me that.
Community may not, he is a
Do you understand what is commonality?
community is a appellant, one of the appellant owner of this property.
You are not prepared. I'm sorry, I shouldn't say like that.
There are several.
For the interest of your client, you should go back, do some research work and come back. This issue is serious. The way you are looking at it, I don't think it is sufficient.
Okay, my lord.
No, I don't want to push you.
No.
It's absolutely your prerogative. You can have your say, or you can come back after a little bit of research work.
Yes.
What I could perceive, you are missing the point. You are missing the point being raised by Mr. Ghosh. Common interest. Look,
One photocopy of this petition.
supply him a copy of the application.
And also a plaint application. I don't have a plaint application. I got.
Now, what is the contention of Mr. Ghosh?
Contention with a
Could you
message.
comprehend that?
No, I am not.
You failed to comprehend that.
Why not? If any appeal is
ভাই সোজা কথা শুনুন, উনি যেটা বলছেন যে কমন জাজমেন্ট একটা ডিক্লারেশন চেয়েছেন, কমন ইন্টারেস্ট রয়েছে সমস্ত পার্টিদের। এই রকম ক্ষেত্রে যদি একজন মারা যান এবং তার এগেইনস্টে অ্যাবেট করে যায়, তাহলে পুরো মামলাটাই অ্যাবেট করে যাবে। দ্যাট ইজ হোয়াট হি ইজ সেইং। You are saying no, right to sue is surviving. You are not taking into consideration the commonality point. Now it's clear. Tomorrow.
No, my lord, it takes all 7 days on.
7 days. What is your name?
Devashish Dash and Kishore.
কপি দিয়ে দাও।
Mr. Devashish Dash, learned counsel for the opposite learned counsel for the opposite parties, seeking an adjournment. The matter be listed on 31st of July. Hey, Aditya.
কবে দিয়েছে? কবে?
এটা কি এসে 50 হয়, এটাই তো জানি।
My lord, I'm for the appellate matter led by Mr. Pathapati. I'm for the appellate matter led by Mr. Roy, my lord.
My lord, I'm for the state led by Mr. Joyanto Shamanto, my lord.
My lord, your lordship, my lord, was pleased to, my lord, hear the matter, my lord, in part, my lord, on the last occasion. Lordship, some queries fell from your lordship. May I, lordship, hand over a copy of the plaint?
Please.
My lord, the plaint is not annexed, my lord. This is, my lord, plaint of, my lord, the suit, my lord, that is filed in Balia.
Now, this is the suit filed in Balia.
Balia. Now, my lord,
Does it cover the?
Orponnama, it does. The Orponnama, my lord, it covers.
And what about the parties?
My lord, the parties, my lord, the vendor of the petition, appellant, my lord, is one of the parties, my lord. Kindly seize, my lord. I'll just indicate, my lord. And my lord, the date is filed by the date is
No, one of the two deities. Shambhihari Narayanji.
both the date is, my lord, 1 and 2, my lord. Kindly seize.
Oh, Shukeshwarnath Mahadevji. Yes.
My lord, may I, my lord, straight away take your lordship, my lord, kindly takes up the paper book, my lord, once. My lord, page 8 of the part 2, my lord, of the paper book, my lord.
Yes.
This is, my lord, is the judgment of the 1955 suit, my lord, the plaint I have just handed over to your lordship. My lord, the judgment starts from there, my lord. Kindly, my lord, takes up the second paragraph, my lord. The plaint allegations of that the plaintiffs, my lord, the last paragraph of that page, my lord, page 8. The plaint allegations are that the plaintiffs and their ancestors were permanent leaseholders of the place in dispute. The ancestors of the plaintiff.
The plaint allegations are that the plaintiffs
of the first set. My lord, I'll just come back, my lord. At that, my lord, the ancestors were permanent leaseholders of the places in dispute. The ancestors of the plaintiff second set executed a gift deed of the places in dispute in favor of the plaintiff of the first set on, my lord, kindly marks the date.
No, who could be the ancestor of Shambhihari Narayanji?
The ancestors, my lord, in the case is that, my lord, that a gift deed was executed on 19th July 1933, my lord. The date is important, my lord. The 19th July 1933 gift deed was executed. Part of that property, my lord, was, my lord, gifted to the deities. And therefrom, my lord, the title flows. Therefore, my lord, the gift deed of 19th July 1933, that is, my lord, the sole contention, my lord, of the plaintiffs. And now, my lord, the added parties.
Who are the plaintiffs? The deities or
the deities in that plaintiff, in that plaintiff, the 1955 suit.
255 of 1955.
Yes.
And second paragraph of that plaint says, the plaint allegations are that the plaintiffs and their ancestors were the permanent leaseholders of the plots in dispute. So my question is, who could be the ancestor of Shambhihari Narayanji and Shukeshwarnath Mahadevji? For my understanding.
Might not have been, my lord, drafted in a, my lord, happy manner, my lord. Their plaint case is that, my lord, the property in this, the suit property, my lord, was gifted to the deities. Why the gift deed, which is, my lord, of 19 July 1933 deed. And now, my lord, the present petitioners of the order, the application, the addition of party application, my lord, they also claim their title through this deed in favor of the deities.
Second petitioner.
The present petitioners,
present
who are,
petitioner.
trying to get themselves inducted in the suit.
Means present appellant.
The applicants in the title appeal below. Order 1 rule 10 application. Rule 10 application has been filed.
by some of the applicants, my lord, in favor, my lord, who claim their title through that deed. Our contention is that.
No, is that pending before this court?
Yes, they were appearing, my lord, on the last occasion. Yes, my lord, kindly
State,
please- kindly
state
take
is claiming that the land is still a Debottar property.
still the vote. Our claim is, my lord, it's a freehold land. Freehold land, my lord, I'll just show, my lord, why. My lord, kindly takes up, my lord, page 53 of the part 1 of that paper book, my lord, lordship will, my lord.
Yes.
The plaintiff in the suit below, my lord, is Nojrul Haq. And my lord, kindly sees. We filed the suit against, my lord, the state of West Bengal and the PLLRO. My lord, opposite party number, the respondent number 3 and 4, they are trying to get themselves added.
No.
Claiming title through that gift deed.
DTs are claiming to be implemented. You have already, they have already been added.
Yes, against that we have come. Against that, my lord, suit, the appeal was, the suit was remanded back. Against that, my lord, we have come.
So you have challenged the order of remand.
Order of remand.
Yes.
Now, my lord, may I kindly, my lord, takes up, my lord, page 8 of that part 2, my lord, where I was, my lord. My lord, page 8, my lord, clearly shows, my lord, that they are claiming their title, my lord, through that deed of 12 July 1933. Now, my lord, whether the moot question was, my lord, whether that deed has been acted upon. Now, my lord, kindly comes to the findings of the court, my lord. Page 12. My lord, issue number 4, my lord. Page 12, it starts from the issue number 4. I'll take your lordship to, my lord, the middle portion, my lord. My lord, it starts with, my lord, the plaintiffs have notified any paper. The plaintiffs have not filed any paper to the same. That the plaintiff first said are. It's, my lord,
Bhumidar.
Bhumidars. Bhumidars in dispute.
Bhumidars of plots in disputes.
Plots in dispute, and, my lord, plot dispute and their possession as such. There is no paper on record to prove that the gift deed, Exhibit 5, was given effect to in papers. That is, my lord, has been affirmed by the judge.
Have you incorporated the typed copy of this judgment?
Typed copy, my lord.
It's otherwise very difficult. Or I need to place it before my air court for transcription. It's akin to what they take in shorthand. Ache.
No, my lord. It has been, my lord, subsequently affirmed, my lord, by the appellate court and, my lord, up to high court. My lord, those are typed, my lord. The lower court judgment, my lord, has not been, my lord.
Yes.
My lord, kindly, my lord, takes up, my lord, the suit, my lord. In view of that, my lord, that the gift deed was never acted upon. Possession has never been physically transferred. In view of that, my lord, the suit was dismissed. The lordship will kindly, my lord, find it at page number 13, my lord.
Now, where is the deed? How the property was dedicated? Deed of endowment, we need to see.
Yes. My lord, I'll just hand over a copy of the deed, my lord. I'll just, my lord, get a typed copy of the deed also. My lord, I'll just hand over a copy.
Hindi version.
No, this is my Bengali. Lordship, my lord, pardons me, my lord, because it has been highlighted, my lord.
No, highlighted, that is not the issue. Should have been better if you could produce the typewritten.
Yes, admit, my lord. But my lord, kindly, my lord, sees their application case, my lord. Kindly, my lord, the case will be clear, my lord. They kindly, my lord, takes up their application. Their only claim is, my lord, I just need to, my lord, show that this deed, their case is, my lord, that they have, my lord, got possession of the their title rests on this deed. And this deed has not been given, my lord, it has been, my lord, proven in the proceedings, my lord, that were placed before, that, my lord, this deed was never given effect to.
No, why it should be binding on them? This declaration, why it should be binding on them? It is a judgment in personam.
No, my lord, kindly consider.
Who from their end represented the suit?
The deities were represented, my lord. The deities were represented there. Now some persons come up as Shivaites, who, my lord, claim their title through the deity. They are not claiming independent title, my lord.
Shankar Doyle, Kedarnath,
yes,
and Ram Nagina. They were the Shivaites.
They were the Shivaites, my
Now
lord.
this added defendants, they are claiming under whom?
Shyam Bihari Narayan Jew and my lord Shankar Dal, my lord, and Shukeshwar Nath Mahadev Jew. Lordship, I have just handed over a copy of-
Ritesh Bhakat is claiming to be the Shivait,
Yes.
who is claiming under Ramesh Kumar Bhakat, and how Ramesh is connected to
Kedarnath,
any
my
of
lord. Kindly cease, my lord.
the
Ramesh Kumar Bhakat is the son of Kedarnath.
Kedarnath.
Kedarnath, my lord. Shukdev, from Shukdev to Kedarnath, Kedarnath to Ramesh, my lord. Kindly cease, my lord. The table I just handed over to you.
Yes. Is it correct?
Yes, my lord. Kindly cease, my lord. There.
If it is correct, then where is Ritesh? Ritesh is the son of Ramesh.
Ritesh is the son of Ramesh, my lord.
His name doesn't find place in your genealogical table.
Yes. You are the descendant of this. Application. Application and copy.
Ritesh Bhagat is the son of Ramesh.
Yes.
Ramesh happens to be the son of Kedarnath.
Kedarnath happens
But
to be the son of
name
Shukdev.
of name of Ritesh is not there in your genealogical table.
Genealogical table, my lord, has ended there. Should have, my lord, gone up one step below.
Why one step?
Yes, my lord,
Ramesh,
Ramesh is the son.
you look at the table.
Yes.
Look at the table.
Yes.
Sukhdev Kedarnath.
From Shukdev is the father of Kedarnath.
Fine.
Kedarnath is the father of Ramesh.
Ramesh is the father of Ritesh. Where is Ritesh in
Yes,
the
my lord.
table?
Kindly see the application.
Where is Ritesh in the table?
That is just what I said, my lord. It is, my lord, it should have come down one step below. It has, my lord, ended up to Ramesh. Should have, my lord, come down. My lord, kindly takes up the affidavit page. Kindly takes up the affidavit page, my lord, of that application. Their application.
No, it is admitted.
Admitted, sir.
Ritesh is the son of Ramesh.
Ritesh is the son of Ramesh. Ramesh is the son of Kedarnath.
Yes, okay.
Therefore, my lord, their predecessor interests were represented in that suit.
Yes,
Plus, therefore, my lord, any order that has been passed in that suit
Fine.
subsequently
This-
affirmed in the appellate court.
this order of learned trial court got affirmed till High Court Allahabad
My lord, I'll just indicate, my lord. Kindly, my lord, takes up page number 39, my lord.
of your
Part 2, my lord, the paper.
part 2. Not legible at all.
This one, my lord, I apologize, my lord, for this, my lord. It should have been a typed copy. Should
No,
have
no,
been
it's
annexed
typed copy, but
There should have been a
absolutely
typed copy.
blackout.
My lord,
Page
the last
37.
portion, my
You
lord,
just read one sentence from page 37. I shall be very happy.
37. I know. My lord,
You
when
know
it
that.
came to my hand, my lord, I also indicated the same. But my lord, I'm
So appeal goes.
appeal goes, my lord. Kindly sees the findings, my lord. It starts at page 39, my lord, the last paragraph.
Now, who preferred this appeal? Shambhihari Nathji, Siddheshwar Nathji, through their yes.
My lord, kindly, my lord, I'm placing reliance, my lord, on the findings of the
Just
High
indicate the
Court, my lord.
paragraph. Indicate the paragraph.
My lord, this is page number 39, the last paragraph. My lord, I'm led by Mr. Roy, my lord.
Yes. You just read out.
My lord, this is, my lord, a bit legible, my lord, for your lordship, my lord.
You read it. I will find it out. You just read it.
My lord, I'll see. This is so because
is
the
so
findings
because
recorded by
findings-
both the courts below concurrently at that the plaintiffs first said had really no interest in the property. They were not its owners and had never been in possession. The gift deed alleged to have been executed in favor was therefore a dead letter.
No.
Therefore, my lord, it has been held up to the High Court, my lord, that the
Yes.
gift deed has got no effect.
So your contention is it's barred by section 11. It cannot be reopened.
My lord,
That's all.
my lord, I'll just take it.
Yes.
And who is applying for addition of party?
Who is that man? Ritesh Bhagat.
No, my lord, your lordship, that is who have filed this application for addition of party.
Who has
That your
filed?
lordship find at page.
Shambhihari Narayanji, Shukeshwar Mahadevji. Yes. Yes, it's
Yes.
with me.
If your lordship may kindly consider who have filed this application.
Hmm.
Application is filed by, may I hand over a copy to your lordship?
Yes, I do have.
It is not Ritesh Bhagat, it is filed by Sri Shyam Bihari.
Yes, yes, he is
The same-
represent.
The same plaintiff. And the deed involved in both the schedules. It's not that one schedule is mentioned for Bordor party, another schedule is mentioned for Hebrew property. The entire deed was taken into consideration. And at the instance of the person, the suit was dismissed, so that the title has been dishonored. Then how on a subsequent the same person can re-agitate
Yes,
this point?
got your point.
And my lord has delivered the judgment order for one in eviction matter where Mr. Basu is arguing one side and Mr. Mukherjee is arguing another side.
Yes, yes.
That judgment I'm relying upon. What is the scope for remand? And my lord, for doing substantial justice, my lord can decide the issue. That your lordship find that is the judgment reported in.
Now, who will address the court? You are representing the 3 and 4. They wanted to be added, or they got added. They got added.
They got added and remanded.
Yes.
the matter.
Please come and have your say. No more time to Mr. Roy. Oh,
I'll tell you that another matter is.
no, it's okay. Section 11, that is all.
Section 11, section 40 of the evidence. Act.
Yes.
That is the only thing, because the person at whose sister and it is a judgment in rain. The declaration in respect, he is bound by that
declaration.
He is bound by that. It is a judgment
We are
in
not bound to
personnel.
them.
Yes.
So far, he
He is bound by that.
is bound by that. He cannot say
Absolutely.
that I am not bound because the
Absolutely.
deity is himself
No,
coming.
he is not saying anything as yet. Let's wait. Yes.
Yes. Oh, may I have what you I can say that. Hello. According to the defendant 3 and 4, their father Ramesh,
Hmm.
Ramesh Kumar Bhagat,
Hmm.
Mohan Kumar Bhagat, and Suraj Kumar Bhagat.
Hmm.
They are the sons of Kedarnath Bhagat.
Hmm.
After the death of Kedarnath, they became the Sevaites,
Fine.
of whose property, the property which is situated in the West Bengal, Bardhaman. But the dedicated to the deity, the plots, the suits, land, that is two from the West Bengal and two from
Just give me half a minute. You have given this copy of the deed.
Yes.
You just indicate.
Type copy in Bengali.
You just indicate the plot numbers involved in
this appeal.
in this appeal.
Yes.
In the deed. That's all. Yes. Please continue.
the plots that is given to the deity that are
Plots dedicated are
তপশিল ক
hmm.
রায়তি নিষ্কর
Hmm.
জেলা থানা ও সাব রেজিস্ট্রি বর্ধমান সামিল মৌজা
Hmm.
কোহরপুর হ্যাঁ অন্তর্গত টিকুরি মাঠ নিজ হরে অধিকারী জমি পশ্চিম অভয় মণ্ডলের জমি পূর্বে দ্যাট ইজ দ্য বাউন্ডারি পূর্বে তারক পানের জমি
Hmm.
দক্ষিণ
একটু দিন তো
page number 3
Hmm. Yes.
page number 3 তপশিলি ক bottom 3
0.3 এই মাঠে
এই মাঠ নিরহরি অধিকারীর জমি
অধিকারী
দক্ষিণে
জমি দক্ষিণে
হুম
খেতু চক্রবর্তী জমি, এরপর অভয় মণ্ডলের জমি
হুম
পূর্বে তার পালের জমি, তারক পালের জমি
হুম
উত্তর ইতিমধ্যে এক কিতা শালি জমি, নিম্নে অদং 10 কাঠা খ 7 বিঘা 2.5 কাঠা রায়ত নিষ্কর। এর মধ্যে ইহার মূল্য 300। উক্ত মৌজা জমি বর্ধমান রাজগঞ্জ পোস্ট লাকুড্ডি সাকিম শ্রী শ্রীযুক্ত
Manohar Das Mohanto Maharaj, whatever. Now, sir,
Again.
my question is, when the Honorable High Court at Allahabad declared that the deed was never acted upon and the suit was decided in presence of your predecessor in interest, it binds your, it is binding upon you as well.
My lord,
Therefore, section 11 comes into play. What is your answer to this? That is the very short point.
my lord, this gift deed is placed to UP Allahabad court in the trial title suit. There, if my lord comes to the judgment degree of the title suit and order and the second appeal, there says that the degree that the deed has not acted upon.
Yes.
But if we go through those judgment degree and order, there we find that the appeal, the title suit has contested by the Shankar Dayal Bhagat. Shankar Dayal Bhagat. Who is the Shankar Dayal Bhagat?
No, who is Kedarnath? Who is Kedarnath?
Oh, Kedarnath.
Kedarnath is your predecessor in interest.
Well, given
Your great grandfather. Your
He-
great grandfather.
my lord, great grandfather, but
Right.
but the name is over there, but the exhibits, the cross, the PW, they are
Why?
taken only the person.
Then you have to file a separate suit. You cannot challenge this in this appeal. Section 11 is there. If you find some infirmities in the decree, very well, you file a separate suit, say that it is not binding on us.
That's why, my lord, I have that added party applications are filed, but the title in the Bardhaman court is stayed by for this FMA. The appeal court says if the decision is made, the interested party should be added.
You cannot have your say because of section 11. We cannot reopen this issue. So far, your status is concerned.
Yes.
Fine. Your predecessor in interest was found to be, what should I say? Not the person upon whom title could be said
But
to have been
schedule also
conferred.
not placed over there. Bardhaman schedule,
Entire deed was declared to be
but now all void has not said.
not acted
Not
upon.
acted upon. But
So
but
what
in
the,
the
what is the
Bardhaman court-
implication? If a document is not acted upon, what does it say?
not acted upon means that when
You
the
you
deed
have
is-
not derived anything out of that deed.
Not only acted upon, my lord, pardon me, but dead letter. What is meant by dead letter?
dead letter.
Dead letter is not a legal term per se.
Having no effect.
So again,
find-
question of interpretation.
The
Yes.
findings of the UP Allahabad court is that
You are,
the
you-
record,
please,
the
please
Leela record has
understand. Please understand, you are claiming under this deed. And Honorable High Court at Allahabad said this deed was never acted upon.
But that judgment is part that given because schedule only for the UP, not Bardhaman schedule
Entire
is not
deed.
placed over there.
These observation,
Documents-
these observation was as against the entire instrument.
My lord, if you kindly go through, it is
There
not
are no
only
two deeds.
partly only UP property has taken into account and all exhibits are deposited in the court only against the UP property, not any document, single document.
How can I and why should I look into this matter in this list? If you want to challenge the degree, very well, you challenge it. No one can stop you.
And my lord,
You can always you are free to contradict me, prove me wrong, but you have to. It should be with sound logic supported by law.
But
I am ready to change my view, but show me the law. Section 11 is a bar. What you are saying, you can say that you can claim your status to be declared by a separate proceeding. How could you challenge this appeal or the decree passed by learned trial court?
if I not got the chance to agitate.
No one can stop you.
No, in the titles there is stayed, added party applications. Stayed.
You cannot have your say. Now difficulty is again, limitation will come into play.
my lord, may I only indicate only one aspect?
3 years. How to tide over that?
When
How to tide over that? Tell me.
when
These
the
are
appellant,
these are the legal
filed
points.
the title suit. When
Yes.
the appellant filed the title suit in the Bardhaman court,
Yes.
they only made party to the.
No, your interest was jeopardized by the judgment of Honorable High Court at Allahabad. You are saying, no, that is not correct. It was erroneous, whatever. Period for seeking such declaration is 3 years from the date of your knowledge. What is that? So, two limbs, Section 11 and Limitation Act. How could your petition be entertained?
Judgment of my lord 63, 6th February 1963.
Where is your senior, madam? Just send for him. I am going to pass the ultimate order. It will be reserved for judgment.
My lord, may I indicate, my lord?
Yes, I am passing it over, but send for him.
Well, state is anyhow contesting. State is contesting.
Yes, I know. So, if this order goes, the matter will be sent back to learned first appellate court.
Appellate.
Sir, may I draw your attention? Now you are quite posted with the points I am looking for. Could you please come back tomorrow with a short note?
Okay. Yes.
Ask your senior to come tomorrow. with short brief note only. Tomorrow, for that purpose, section 11 and limitation.
And my lord, may I just indicate, my lord, one more point, my lord?
In your written notes.
My lord, so that, my lord, it would be to their advantage, my lord.
Whisper into his
My
ear.
lord, my lord, my
Who
lord.
is stopping
Certainly, my
you?
lord, I'll come back, my lord.
Just share your views with your friend. No one is stopping you. এই এটা করুন তো ম্যাডাম এই সৌরভ লিখুন Heard Mr. Partha Pratim Roy and Dutiman Banerjee for the appellant and Mr. Jayanto Shamant. Where is Mr. Shamanto? Is not there. Should I record your name? Yes. Mr. Ghosh for the respond number 3 and 4. Let the matter be listed tomorrow when parties will submit their brief notes on argument. Okay.
Since morning.
Yes, I have seen you. I was quite surprised. How could you afford so much time? Idly sitting here.
It is very difficult from coming from that building, main building to this building.
Don't take the pens.
But,
Yes. What is your number?
Item 15, next matter.
Next matter.
Next matter.
Yes.
But
Yes.
already it appears, my lord, the application under order 22 rule 10 has been fixed for hearing today.
Okay.
As it appears in the list.
Okay.
But so far as the application is concerned, my lord, they're claiming, my lord, a transfer from the earliest owner. My lord, not the deed itself has not been annexed to the application. Then how could I know, my lord?
In any case, you need to give a copy to your senior friend. At least prima facie to
not
satisfy
even-
himself. Yes, you have acquired the property.
Not even, my lord, in the application, there is a specific date. The vague date has been given.
No, he is taking note of that with liberty.
I want, my lord, the appeal itself be disposed of along with this application. No problem. Next week, any day next week, according to your lordship's convenience.
File a fresh application along with all the annexes. I'll serve upon.
How long will it take?
2 days. Young man, he can move first. He won't take more than 2 days.
I'll keep it next week, and even in the meantime, I will serve a copy upon.
Next week for hearing of the appeal
Along with this
along with application, you will be given a right to assist the court.
Yes.
Look.
Just one thing, my lord. As it is a change brief, even all of the documents are not there with us also. My lord.
Always this type of request should go to the senior members. You just request your you provide him with the necessary papers. You just before approaching the court, you should approach your senior first. Yes. Take down. Heard Mr. Ghosh, learned senior counsel for the appellant, and you and Mr. Dipto Banerjee representing the petitioner. Stop. It appears that the instrument on the basis of which the petitioner wants to get implemented under order 22 rule 10 has not been annexed to the petition. Liberty is given to the petitioner to file supplementary petition incorporating the instrument with copy to the. You are representing the appellant.
I'm appellant.
And he will be the sole respondent.
My lord, I am the applicant in can 2 and.
Yes, if your application is allowed, you will be sole. Fine. the with a copy to the appellant stuff. Let the matter be listed on 31st for hearing of appeal along with application.
that.
Can it be 1st of August instead of 31st?
1st of August. Very well. মঙ্গলবার
মঙ্গলবার করলে বারটা ভালো নয়।
Well, let's say.
দিন পরে আবার ফিরে গেলেন কেন বুঝে 2 at 12, no?
Yes,
That amendment.
yes. No, I was also wondering if it commends to your lordship and my learned senior friend that all the applications may be heard along with the appeal itself. If the court feels that there is anything in which is required to be done, the court at the time of hearing of the appeal itself, my lord, can do it. My respectful submission was, my lord, that now what happens is today he's come up with this amendment, tomorrow he'll come up with another amendment, then it will all go on forever. Let the appeal be taken up, all the applications together. I have no problem.
This is an application under Article 227 challenging the order number 36.
Yes, sir.
Whereby the prayer for amendment was either rejected or allowed, I don't know.
Yes, sir.
Your petition was rejected.
Allowed.
You were challenging
I
that
am
order. So don't challenge, let it be decided in the court.
Well, it's allowed, my lord. Now, once this is allowed, then all the applications, my lord, will be allowed and my entire thing will go.
All the applications.
My lord, all applications under order 39 rule 7 and order 41 rule 27, all will be allowed. Because this amendment is allowed. Now, if that is so, my lord, then the entire appeal goes. No. This is the apprehension and this is the truth. And moreover, when this amendment is not required.
Purely hypothetical.
তাহলে আমি মামলা করব। আমার Abdullah, I tell
No,
you,
that is one aspect. Amendment is not required for adjudication of the
yes,
suit.
not required.
If you can stick to that, let us decide
I
that
am
point.
sticking to it, absolutely sticking to it.
So let us decide your petition on merit.
Kindly decide. Kindly, my lord, your lordship has heard it. I just remind your lordship. My lord, kindly
No,
see the
today
impugned order.
speaks for Mr.
My
Rao
lord.
to
Just
show
remind
some.
him one aspect in the matter, looks to the impugned order once.
Yes.
Completely unreasoned. Doesn't even take into consideration, my lord, that there is an order 41 rule 27 application pending. Completely unreasoned. 2 lines. Apart from the merit, this order cannot stand. Now just
That is correct, very cryptic. Why it is, why the amendment is required, what is.
The division bench yesterday, my lord, has passed an order that it is not for the higher court to supply reasons.
Your lordship has heard. Your lordship can supply hearing. For that reason, the order income should not be set aside. And the learned court bureau has come to the conclusion with an observation that this kind of amendment shall not prejudice.
What kind of amendment?
Very simple.
Where is that?
My application I have annexed. Your lordship, and yesterday I drew it. Very simple.
What's the object of the order? Only single line. Allow it, don't allow it.
An observation that this will not prejudice the right.
Which will not prejudice. That is missing. That is what rightly pointed out by Mr. Chatterjee. Order is cryptic. It doesn't consider the other matters.
Kindly seize the amendment, my lord. Kindly seize 24D once at 170. Dangerous. If your lordship, my lord, at the appellate stage, at the time of argument, if this is allowed, kindly seize that the respondent plaintiff has several land and building within 10 kilometer periphery. Suit gone. It is not that, my lord, the plan that the building has come up, my lord, in a day.
If one innocent case do possess such property, there is no harm to disclose on the part of my client.
I will face consequences if
You
I
have
am not
suppressed.
I will face consequences. You were unable to prove anything before the court.
So far the nature of amendment is concerned, my innocent client will not be prejudiced in any way.
Completely not.
Why my innocent client is afraid
Afraid?
Such type of amendment. Only subsequent events I want to bring on record.
You have annexed your application.
Lord, kindly,
At
I'll
page-
take your lordship one by one. Kindly turns to first page 61. I'll just remind you
61,
quickly. 60. Quickly, I'll
61,
60.
60,
Yes. Quickly, I'll take your lordship why I say my lord, that
paragraph
this-
12.
Yes, my lord. I'm so grateful. This is, my lord, his averments made. On this, my lord, he has, my lord, pleaded whatever he has pleaded. He has given evidence, whatever he has given evidence. Sees the, my lord, I'll show you, lordship. Yes, that this defendant submits that the plaintiff recently inducted a new tenant in a shop room which was lying vacant under the control of the plaintiff, and the plaintiff has sufficient accommodation for her own use and occupation. And as such, the particular shop room is not at all required by the plaintiff. That this defendant further submits that the defendant never allowed any person to occupy the room in question after the demise of their father. I showed you lordship this yesterday. So this is so this is his, my lord, main written statement. Now see 68. This is his additional written statement. 67 first, paragraph 12. 67. Paragraph 12 in the middle. That this defendant submits that the plaintiff recently inducted a new tenant in a shop room. My lord, kindly got it. In the shop room which was lying vacant under the control of the plaintiff, and the plaintiff has sufficient accommodation for her own use and occupation. This is additional written statement. Turns to 68. Paragraph 14. That the statements made in paragraph subpara 1 of the paragraph 6 of the plaint are not true and correct, that the alleged shop room in question is not at all required by the plaintiff for her own use and occupation as falsely alleged in the said paragraph, and the said shop room is not required by the plaintiff. That this answering defendant most humbly submit that the plaintiff totally suppressed the entire picture of her present occupation. That's his plea. Occupation, and she has several vacant shop room at present which is under control of the plaintiff, and from the suit premises there is better accommodation which is vacant and under control of the plaintiff in the plaintiff's new building. Every plea is there. Now, my lord, in addition to this, he now says that I have constructed, my lord, 10-story building. My lord, 10-story building, even if I have constructed, my lord, which I have admitted about my construction, my lord, if that 10-story building did not come up, my lord, in a day, and it is from me to, my lord, I have admitted that presence of that building in my, my lord, objection. So these are all part of record. This is only, my lord, successfully, my lord, I would say.
You have admitted this fact.
Yes. Kindly seize, my lord, my objection.
Admission in different way.
Whatever it is an admission. 130. 32. 130. Yes, 130.
130.
130. Looks to 16. I have admitted that. And I have said that prior to institution of the ejectment suit against the appellant, the tenanted room of Motilal Shah, my lord, it's in the middle. I'm sorry, my lord, I skipped over because I don't want to waste my lord's time. Of Motilal Shah, which was divided into two parts by his son and his son's wife, prior to 2004 was surrendered, and the same were let out to Subhash Engineering Company and Trilochan. I further say that the respondent is not at all aware about Parishmal Surana and or his alleged tenancy as stated therein. My mother had or has no tenant by the name of Parishmal Surana. With regard to tenancy of HON'BLE bed, I say that the room which was occupied by the said is measuring about 70 square feet, which he allowed a third party, Narendra Kedia, to occupy the said room, and having no other alternative, the said Narendra Kedia was accepted by the respondent as a tenant on surrender of tenancy by HON'BLE. These are all facts which are admitted by me. Construction, my lord, your lordship will find that.
Paragraph 17. Yes.
17. These are all there. And order 41, rule 27, my lord, may I remind your lordship, is also there.
He's brought all this on order 41 rule 27. So if the court at the time of final hearing, when he hears below the appeal, along with the order 41 rule 27 application, will decide. Everything is there. This is just a ploy, my lord, to, my lord, delay the proceedings, nothing else. And the court doesn't even consider any.
Yes, Mr. Raut.
Yes, kindly allow me to proceed in my own way.
Yes.
Yes.
So you are preempting me from raising any question. Very well.
But I will have to leave court, my lord, because of a personal problem.
Do you have another matter with Mr. Mukherjee? No, Mr. Basu is there.
Not today.
Very well.
Mr. Chatterjee is here, my lord. He will grateful to us.
Yes.
First of all, you also kindly allow me to place the amendment application.
Yes.
Order should be, your lordship kindly come to page 130, 113.
113.
My lord.
Yes.
But straightway, your lordship kindly come to paragraph 4, page 114.
114.
My lord. Paragraph 4. My lord, during the pendency of the appeal, plaintiff respondent already has got position in respect of 3 rooms. My lord, so far my disclosure in the additional instead which concern your lordship has found only one tenant. Only one tenant. At that point of time, it was within the knowledge of my client that only one point has vacated the particular subroom. But subsequently, we came to learn that as many as 3 tenants, 3 subrooms has already vacated by 3 tenants. Your lordship kindly allow me. 3 subrooms which have been vacated and delivered possession unto the respondent by its respective tenants. Namely, I have specifically disclosed the names of tenants. Motilal Shah, one Paresmal Surana, and one Navratan Malpaik, who surrendered his tenancy in favor of the respondent in first week of April 2014. My knowledge, your lordship kindly take a note of, in the first week of April, I came to learn, and immediately we took out that application for amendment. Now, your lordship kindly come to paragraph 5, that the respondent, after getting possession in respect of the said 3 rooms, out of which 2 subrooms, which have been handed over by the tenant, Motilal Shah and Paresmal Surana, have kept under lock and key, and the said rooms under possession of the present respondent. Now, my lord, very important 6, that the subrooms handed over after surrendering possession by the Navratan Malpaik has very recently been let out by this plaintiff respondent on 1st day of May 2000. All these particulars are required, my lord, on 1st day of 2014, and whereby a newly inducted new tenant, Radhika Solution, and the old tenant said Navratan Malpaik, after surrendering his tenancy, also applied before the Electric Supply Authority for refund of the security amount deposited for the meter, which stood in the name of Navratan Malpaik, bearing consumer number such and such. Now, my lord, paragraph 7. Paragraph.
Yes.
And the newly inducted tenant of the respondent has also applied for new meter. He surrendered his old tenant, surrendered his meter, new tenant applied for getting meter in his name.
Yes.
My lord, the paragraph 7, that the respondent plaintiff had several land and building within 10 kilometers within the periphery of Kolkata Municipal Corporation, and the respondent plaintiff willfully has suppressed the material facts before this landed court. And normally the super construction is concerned paragraph 8, that the respondent plaintiff constructed a commercial multi-storied building just by the western side of the shoot premises, and she had inducted one Sitaram Saraf in the ground floor of the said newly constructed building, and the said tenant is occupying the said tenant portion as godown. The next paragraph, that in the said building, the respondent plaintiff recently inducted some new tenants in the building, and some rooms are lying vacant under the control and possession of the respondent plaintiff. The last but not the least, paragraph 10, the respondent plaintiff has totally suppressed that except the property, the respondent plaintiff has some other suitable vacant accommodation in the premises number 156A Mahatma Gandhi Road, Kolkata, and another is 12/2 Old Post Office, Kolkata. It came to our knowledge 2 other premises is there, alternative accommodation. We have disclosed. But if all these, I'm asking myself, if all these particulars are not brought on record, then certainly my clients have been precluded from producing evidence. No doubt the application order 41/27 is pending. That was not touched by the Learned Court Bureau. Learned Court Bureau simply allowed the amendment. Until and unless the application prior for amendment is allowed, I cannot invoke the provision of order 27. And for that purpose, two other application order 27 order pending. And your lordship takes up to the reply of the paragraph, all the paragraph 5 to 4 to 7, 8 of my application. Even see, firstly, they have denied. And secondly, yes, I have constructed, I have got 1/4 share and all these things. In this way, they have somehow bypassed. My learned friend, Mr. Chatterjee, yes, my client has candidly disclosed it is not there. There has been suppression, total suppression of material facts, which my client has come to learn later on. That way the application was filed, and that has been allowed. And so far this type of application is concerned, I will place before Lordship the Supreme Court decision, 3-judge decision. Yes, such type of amendment is vitally necessary for the purpose of adjudication of the disputes. I am referring very nice. I think subject to Lordship and approval. This case is squarely covered by this judgment. I am referring to 1981 volume 3, Supreme Court cases, page 103. I have got the Xerox copy of the judgment. Page 103. Your lordship kindly first out head note, thereafter paragraph 14, 15, 16. Everything has been discussed in that. Your lordship filed from the judgment, the High Court rejected the prayer, but Supreme Court allowed. I am reading here also.
Yes.
I am reading from the head note. First. The rent control and eviction, a ground of personal requirement held. Such requirement must continue to exist till the final determination of the case. So, appellate court must take into conclusion the subsequent events showing that the landlord's requirement have been met and must mold the trial court defense accordingly. Amendment in written statement sought by the tenant under Order 6 Rule 17 CBC, pointing out such subsequent events being relevant cannot be rejected by the appellate court merely on the ground of laches. Although in this particular case there was no laches on our part. The moment we came to learn, we applied. We came to learn in April and we filed the application on 9 June. Paragraph 14, 15, 16.
Very well. That's it.
Another decision I am referring to, my lord. The power of the appellate court. It is known to your lordship already. I am referring another judgment reported in AIR 1977 Calcutta, page 108. Order 6 Rule 17, court can take notice of subsequent evidence in the discerning and application for amendment of plain. Power of appellate court. It has been enunciated in this judgment. Appellate court is quite competent to allow the application taking into consideration the subsequent events.
No one is questioning the competence. Question is whether it is required or not.
My humble submission, appellate court has not committed it wrong, considering the backdrop of the whole case. But we disclose enough. Those facts were carefully suppressed by my litigant client. Well, had it been brought on record, I think the fate of this would be otherwise. Since it is a ground on the ground of all the grounds were negative by the learned trial court, only on the ground of regional requirement user degree. Only on that ground.
Very well. Give it. Hey, Saurabh Babu. Reserve for order. ভেতরে পাঠিয়ে দিয়ে বিকেলবেলা এটা ডিকটেশন দেবো এখানে বসে সৌরভ বাবু যখন থাকবে তখন বার করে দেবো দিন ডাকুন
Obliged.
So you are not representing anyone but yourself.
Lordship, Lordship,
So
Lordship,
take care of your robes.
Lordship, yet
Mr.
I am
Basu?
yet to be substituted.
That's why you're appearing.
Yes.
Sir?
Lordship, the only thing is, assuming I have been substituted right now, assuming there have been some subsequent events after that, and as per the direction of the Honorable Division Bench, it started with your Lordship.
It seems that you are representing someone as his or her advocate. You are not
My lord, that
representing
is-
yourself.
My lord, I've spent more time. My lord, I've spent more
You
time.
cannot appear. I mean, this. No, but this is a petition, my lord, where my client wanted to add. Now the person who is sought to be substituted in place of Mr. Subrata Bose, that has been challenged. So now, my lord, in the trial court, substitution affected. The person who we intend to be added as a party, he has been added as a plaintiff.
Okay.
Lordship,
So
the
that's why, my
base-
lord, it does not to be considered by your lords. Can you see the order impugned?
Lordship, the only part is that I want to make my submissions with regard to that there's a difference between an impleted defendant and a
But
substituted.
you
defendant.
remove your gown and come.
Lordship, I had taken leave, right?
Meantime, colleague, but I failed. In the other capacity, I failed, my lord. I failed. So kindly see the last portion of the order.
What's the matter? Partition suit.
Kindly come to the order. Order in portion. Order 1, Rule 10, filed with reference number 1 is hereby allowed on contest.
No, Mr. Basu is claiming under whom?
He is son of Mr. Subrata Bose died.
Subrata was died.
And
This
it
is
is difficult for his mother is sought to be substituted under order Rule 10, which subject matter challenge before my lord in another capacity. Because there was a locker. Locker, according to the case, maintained by his mother and father. That's why my client want to implead him, her. Implementation allowed. That was challenged before a lordship's court. It has not been touched. In the meantime, my lord, it is illegal could have it. Mr. Bose is Subrata Bose is not with us. So now normally, my lord, he and his mother has been impleaded as a party in the suit. If it is added in the suit, everywhere here they has to be added. If they are added here, then my lord, order 1 Rule 10 application become redundant.
Lordship, that's the difference. When order 1 Rule 10 was the order was passed, she was being impleaded as a defendant, as a co-sharer amongst the co-sharers. But my lord, this order
by the order impugned, Srimati Sutapa Bose has
Lordship.
been impleaded
Lordship.
as defendant.
Lordship.
Fine.
Lordship.
Now you have challenged this order.
Lordship, why, how it was brought in, the reasons behind it. My lord, I have to submit on the points
so
of
long-
Article 70 Limitation Act.
So long your father was alive,
Lordship.
your mother could not have been impleaded as party.
My lord.
That is your point, perhaps.
Not only that.
She was not a co-sharer.
Not only that.
Now, with the death of your father, she has acquired
No, my
interest.
lord, not only that, not only that. The reason behind impleading her is also barred by limitation.
Now, in these changed circumstances,
It is already. It is already. Because I have to submit, I have to submit
No,
on Article 70 of Limitation
the
Act.
point is now, what's the point there? Now,
Because-
subsequent to
because
the
my
date
lord,
of
subsequent
Mr.
events I
Basu.
was bringing, I'm
Mr.
sorry, I
Basu,
apologize.
with the death of your father, who was admittedly a co-sharer,
Lordship,
you and your mother stepped into his shoes.
Lordship,
So you are now co-sharer.
Lordship.
With that, this order lost all its relevance. What is left?
My lord, kindly allow me. This order has given rise to a parallel proceeding wherein, because an allegation has been brought that she had the jewelry of my grandmother and she bought her own property from that jewelry. On one hand, there is an allegation of she being implicated of thievery. My lord, I will call it.
No,
thievery.
is there any proceeding under IPC?
No, my
No,
lord,
then
my lord,
don't use that term.
My lord, kindly allow me. I will satisfy your lordship. Kindly allow me that the point is that she has her self-acquired property.
Let us first understand what he is want to say. This order will stand, will go. The order impute will stand or go. Even if it is goes, no matter.
My lord, if it goes, the proceeding emanating from it also goes in the lower court.
Proceeding.
My lord, there is a proceeding because there has been an amendment to the written statement wherein my mother's properties, the first substituted defendants' properties have been included in the schedule. Because of these, and there is, my lord, my lord, there is also one. I apologize, my lord.
Mr. Basu, you are claiming under Mr. Subroto Bosch, if I am not wrong.
Yes.
Yes, my lord.
Now there, Mrs. Basu has been implicated as defendant.
Lordship.
She can file her written statement. She can file her written.
Now she can.
No, with this order, when she has been given the status of defendant, with that she has been given the right to have her say. Now, as plaintiff, what she will be doing? So far the allegations are concerned, you cannot stop anybody raising allegation. The point is, pleading is to be proved. I can say so many things.
My lord, then kindly gives me at least till Friday. Let me come prepared a little bit more.
Does it really?
These questions have arisen because.
But up till now, he has not answered my question. He should not answer my question. My last query only to answer. But my question is, what is asking for? This order impugned by him will stand or go. Result is same.
No, my lord, it is not the same. No, my lord, the order goes. Order, my lord, I will still be praying for it to be set aside. My lord, if possible, if I may be permitted, may I bring upon a small application for bringing in subsequent events?
What's the point? What's the point?
Bring it on record so that I cannot go back on my words. I cannot go back on my words. My lord, I am at the end of the day an officer of the court.
It will be having an effect of.
You are not now. You are not.
No, now you are representing your interest.
No, you are not on ropes now.
Now you are representing your interest. We are not on that. Look, for all practical purposes, your mother has now acquired interest in the suit property.
Lordship.
So she has to be there in the suit. There is no way out.
I am not denying that she doesn't. I am not denying that she doesn't have to be in the suit right now. Right now, she is there in the suit right now. But before the demise of my late father, my lord, she was not to be made.
Fine. You cannot stop. You cannot stop the other side, the defendants or plaintiff, I don't know, from making allegation regarding the custody of the ornaments, jewelry of your grandmother. That was there. Now they can come with the same pleading.
My brother, I can feel his sentiment. There is an allegation against his mother.
No, don't look it from the point of view of 378, 379, nothing of that sort.
So I could appreciate, but today the circumstances change and it is a partisan suit. Everybody is plaintiff and defendant.
My lord, allow me to come back with.
Why can't you?
I have no problem. It is continuing 34 years since I joined here. The matter.
No, I think.
Let me continue.
Who is Supriya Basu? You were also in the profession.
Yes.
Both of you understand this.
No, unfortunately, Mr. Basu also shares our same surname, so he becomes part of the family.
Fine, give him some share. You decide it.
My lord,
Let them settle.
my
That
lord,
is my
he is
share.
kind enough. My uncle is more.
Why can't you sit and decide it?
See, whoever sitting, leave the brief.
My lord, last occasion I have given a
Never.
proposal and Mr. Basu was also there.
I was there, I tried my level best. But if the plaintiff said suit should be decreed and defendant said suit should be dismissed,
My lord, I
that there be
didn't
any
say that.
settlement?
I did not say
Look,
that.
this is a suit for
My
partition.
lord, I was ready to give up a part. I was
No,
ready
don't
to
give
a
up.
part.
Don't give up. What is the pleading? Share is admitted.
Admitted shares.
Then,
For both sides.
then preliminary degree yet to be passed.
Lordship.
I shall give direction. I shall give direction to take recourse of order 10 and pronounce the judgment on order 15 within 7 days, keeping this matter pending.
Well, that can be done. Let me pray for it. Let me come back then with the same prayer.
No, your prayer is not at all necessary.
Power is there with the court.
227 I am exercising. Simply direct the court, give me the copy of the plaint and your
My lord, I
defense.
don't have one now, right now. I don't have.
We have tried one.
No, then let me try my hand. Give
Harm will do.
Give me the copy of plaint and written statement filed by respective parties.
My senior tried.
And we had.
Stop discussing. Your discussion will not yield any result.
Failed. Let SP Rajchandri failed. Mr. Bimal Chatterjee failed. I have failed all time.
So count me out. Give me the pleadings. Let me see. I am not interested. I am not interested to lend my ears to any of you. Give me the pleadings. On the adjourned date, come back with the plaint and written statement copy.
The last order was.
You forget that order. Now I shall exercise my jurisdiction. How could a trial court sit over the plaint when shares are admitted?
My lord, I will be very grateful if this sword goes over off my head.
Specifically admitted, it is there.
What do you mean by specifically admitted? I had an into.
Lordship, may I be permitted to file the application?
File what?
A small application for subsequent events.
No. This is not a suit for reasonable requirement.
No.
I don't need any subsequent event. You are now heard Mr. Sandipto Basu.
Sandipto Bose, my lord.
Bose, okay. Sandipto Bose. The petitioner number
1A, 1B.
1A and 1B. The
For
substituted petitioner, whose right to sue survived upon the death of Sri Subroto Bose. And Mr. Saptangshu Basu, learned senior counsel representing the opposite parties. Stop. Mr. Bose is seeking an accommodation. Let the matter be listed on 31st of July.
Lordship, 1st of August.
Very well. 1st of August 2023. Stop. In course of hearing, this court has been apprised of the fact that this is a suit for partition where shares of the parties are admitted, and in that sense parties are not at issue. Stop. Under such circumstances, parties are directed to submit their pleadings on the adjourned date. Pleadings before the learned trial court on the adjourned date. If I find share is admitted, I shall ensure your preliminary degree within 3-4 days. Don't, you are an advocate, quite senior. This is a suit for partition and you are wasting judicial time unnecessarily. Come back with pleadings on the adjourned date. Plaint and written statement, that will do.
I apologize for interrupting your lordship.
Don't apologize. Come back with pleadings. Yes, not accepted. Come back with your pleadings. Yes.
I think now this is the right time. Probably my lord can do anything, something in this matter.
Please kindly.
No. We don't take recourse to order 10. Once it is taken, everything will be shortened. Yes, your friend is waiting for you. Yes. Better you concentrate on litigations where your service is hired. Why you are wasting your talent unnecessarily? Yes, call the list. Very well, do that. Do that within these 7 days before I pass any order. Yes, call the list.
Sixteen, my lord, I am for the respondent. Let
Yes.
Mr. Sukanta Chakraborty. My lord, Mr. Chakraborty is having fever, my lord. He has left the court, my lord. My lord, I am praying for 2 week adjournment.
Why? Fever will persist for 2 weeks.
As per instruction, my lord.
No.
Well, at least 1 week, my lord.
What is the suit for?
Shoot for recovery of past position against the tenant, which
As a tenant, you are the landlord.
Landlord.
What is your good name?
Zubair Ahmed.
Asunto.
Well, at least 1 week.
Suggest a date. Heard learned counsel for the parties, Mr. Zubair Ahmed. Learned counsel representing the opposite party is seeking an accommodation. Let the matter be adjourned to appear on 2nd of August
Well,
under
not
the heading hearing.
Let it be on 3rd.
Third. Third. You are the
I'm for the respondent.
respondent. You are for the come prepared on that day.
My lord.
Then
17, my lord, I am for the appellant, my lord. In this matter, my lord, talks of settlements is going on, my lord. For that, I have been instructed for.
you are for the respondent. When did you initiate the process? Process of settlement?
Suggestion or
Suggestion. Okay, let me see.
one sitting has taken.
So it's going on. Suit for partition. So with your consent, the date was fixed. Yes, Nento. Look on. It will be over. Heard learned counsel representing the parties. Talk of settlement is expected to take shape.
As per instruction, we need 2 weeks or 3 weeks time.
Why 2 weeks is sticking? You are sticking to 2 weeks. Why?
As per instruction.
Who is giving this instruction? Where is your client? Ask him to pay for the judicial time. I shall adjourn the matter. Ask him. Per week 10,000. Ask him. Per week 10,000. That is the unit. Now ask him how much weeks he is actually in need of.
At least 2 weeks we given.
2 weeks, 20,000 cost.
My lord,
Yes.
my lord.
Don't toy with this. You know, heaps of cases are pending. How could we afford this luxury? 7 days time. In the meantime, it should be settled. When they are in the process of settling the matter, why they should kill time unnecessarily? And if they want to afford that luxury, ask them to pay. Take steps by, be reasonable, be reasonable.
By 3rd, my lord.
By 3rd of August. Let the matter be posted on 4th of August under the heading for orders.
Well,
Either you settle the matter or you come and address the court.
much of
Civil revision, yes.
We are opposing that.
But I am take to appear this application, my lord. This is 340 application. There have been a suppression of material fact, my lord. There have been.
Let me file.
What happened, my lord?
You are Mr. Arifin?
I am Mr. Arifin.
Yes.
In this matter, my lord.
What is the order impugned?
My lord, this order, my lord, this is a dispose of matter, my lord. In the civil
Disposed of matter?
Yes, my lord.
Oh, 340.
340. I have filed an application.
Yes.
340.
Why 340?
Yes, my lord. Kindly, my lord, comes to my lord, page 67 of my lord, the impugned order which has passed in this revision application. Whatever matter, if I give you see the background, my lord, yeah, my lord, are challenging an injunction application, but a revision has been filed over here. In that revision application, my lord, the petitioner, my lord, tried to bring one injunction application which was, according to him, was that it does not contain any schedule. Now, my lord, in that, my lord, we file a supplementary affidavit, my lord, and we show, my lord, that the document which they are trying to rely upon before this court is false, my lord. Because
forged document.
Forged document.
Who decided that?
But the judge was sitting here, my lord.
No, who was the person decided that the document was forged? How it was decided?
If you order, well, there is a finding.
Huh?
If you order, the order passed by the Honorable High Court, there is a finding that I want to show to you.
Okay.
Kindly comes to my lord, page 67, my lord. This is the order passed in this show, my lord.
67.
Yes. I will start with page 67, judgment dated on 10th of May 2018, my lord. Passed by Amitabh Justice Chatterjee, my lord. Kindly come to the relevant portion, my lord. I will not place the whole thing, my lord. Only the relevant portion for this application which is required, my lord. Kindly come to page 70, my lord.
70.
70, my lord, from paragraph 8, my lord. During the pendency of the revision application, the petitioner has filed a supplementary affidavit which was affirmed on 31st October 2017 by one such and such Pradhan, Shailendranath Pradhan. In this supplementary affidavit, the petitioner had annexed one purported injunction application stated to have been filed by the opposite party number 457.
Hey, Adito, কি কিসের এত চেঁচামেচি হচ্ছে কোথায়? Overlap করছে নাকি? Yes.
The learned advocate appearing for the petitioner had made submission relying upon, this is important, my lord. The learned advocate appearing for the petitioner had made submission relying upon the said injunction application that there is a schedule. There is no schedule in the said injunction application. And so the order passed by both the court below restraining the petitioner from interfering with the said scheduled property is erroneous. So they relied upon that, my lord. In order to counter such submission made by the learned counsel for the petitioner, the learned advocate appearing for the respondent number 7, 8, 9, and 10 in the present division application had filed another supplementary affidavit, which was affirmed by one Anil Pradhan on 7 December 2017. In the said supplementary affidavit, the respondent have annexed the injunction application after obtaining a certified copy of the lower court. From the said copy of the said injunction application, it is evident that both A schedule, A and A1 schedule have been given in the injunction application. It is also apparent from the injunction application, which is annexed in the supplementary affidavit dated 31st October 2017, filed by the petitioner, is not a genuine one. This is the finding of the court. During course of the hearing of the instant civil revision application, the learned advocate representing the petitioner had also accepted that the inter alia that the said injunction application, which was annexed in the supplementary affidavit, was not a genuine one. That is their admission, my lord. Rather, the injunction application which was annexed with the supplementary affidavit filed by the respondent number 7, 8, 9, and 10 was a genuine one. So not only that, my lord, the court has come to that finding, but it is their admission also. Now, my lord, if I can take your lordship to that those documents, but purported documents which my lord they have annexed. My lord, kindly comes, my lord.
First, you tell me this is a suit for?
My lord, this was, my lord, what happened, my lord, this is an application was filed under.
This is a suit for
Well, this is a suit for setting aside a compromise decree, my lord,
Okay.
under order 21 rule 90. My lord. In that connection, injunction application was filed, we got injunction. Thereafter, my lord, in appeal, again we got injunction. That was challenged before this honorable CP court, my lord. And here also, my lord, the honorable judge has given us injunction, and there, my lord, they wants to impress upon the court that injunction cannot be given because in that court we have not given any schedule.
Yes.
Now, my lord, kindly come to the purported document, my lord, which was under challenge, my lord. My lord, your lordship will find, my lord, their supplementary affidavit starts from page 18.
Yes.
Now, my lord, page 18, my lord, your lordship comes, my lord, to my lord, this is the injunction application which they was to impress upon the court.
So,
yes, kindly see, there is no statement. Now,
one document was shown before the court without any schedule,
yes, ma'am, that
which is factually not correct.
Yes, ma'am.
Certified copy shows otherwise. That prompted you to file this application under section 340. That's it?
Deeply obliged.
Please, take down. This proceeding stems out of an application under section 340 of the Code of Civil Procedure. Yes. Heard Mr. Arifin, learned counsel for the petitioner. My attention is drawn to the order passed in CO number 1197 of 2007, 1196 of 2007, passed by Honorable Justice Amitabh Chatterjee. In paragraph, upon perusal of the said order, I find that in course of hearing, learned counsel representing the petitioner relied upon copy of the injunction application bereft of any schedule of property, and it was submitted that learned trial court committed error in passing the order of injunction in an application which did not contain any schedule stuff, but subsequently certified copy of the application was produced, and it transpired that the petition did contain the schedule of property stuff. Honorable Justice Chatterjee, comma, bracketed it in, as his lordship then was, observed that the document relied upon by the learned counsel in course of hearing was not a genuine one. Stop. This observation inspired the petitioner to come up with the application under consideration. Stop. Section 340 of the Code of Criminal Procedure, এটা set out করে দিন, ঠিক আছে? Section 195 of the Code of Criminal Procedure, এরপরে লিখবেন, says, বলে আবার ওটা set out করুন. In order to invoke the provision of section 195 of the Code of Code of Criminal Procedure, cognizance is to be taken of the offense punishable under section 172 to 188. Stop. But the fundamental requirement in order to for invoking the penal provision is to see the mens rea or the criminal intention. Stop. An advocate, while presenting the case of his client, admittedly produced certain document which was not complete. Stop. There is nothing to indicate that an attempt was made to mislead the court with kind of mens rea to commit an offense within the meaning of the Indian Penal Code. It was rather an incident arose because of improper instruction. Stop. This is not a fit case to spend judicial hour for holding inquiry under section 340 of the Code of Criminal Procedure. This application does not merit any consideration and is dismissed, however, without cost.
That too, in fact, there are two applications in the record. We got the certified copy of both.
Fine. It's over.
We have
Please.
not as your
If the document, my lord,
If you argue further after I pass the final order, then I shall take 228. Do you know 228 of IPC? You are referring to 172, 188. Do you know? Do you have any idea? Don't push me for that, please. I have passed the order. It may not be to your liking. It is subject to appeal. Don't argue.
I bow down to your lordship.
Please.
Your lordship observation. Only
Please.
just I want to show.
No,
I was.
you are not permitted. Don't push me for 228. Call the list.
Deeply aware.
For the petitioner, my lord.
Yes.
But this is a preemption application.
Preemption application.
Yes.
What's the issue?
My lord, 2 points has been rejected. I'm the preemptor. Firstly, my lord, the learned court below is observation that a right of a holding is not a co-sharer and he has the right of preemption. Though
Now holding concept has gone. Yes.
And second point, learned judge is of the view that I am not filing the application within the time of 4 months because I am the adjoining owner, not the
So
co-sharer.
basically your petition was rejected on the ground of limitation
Yes.
and on the ground of co-ownership,
Co-sharer.
co-sharer.
And
Now the concept of co-sharer with the advent of amendment of this
14th
has gone. Then what is left?
Then my lord, it should be allowed.
It should be allowed. When
Only
there
one
is no
point there, my lord. Only 1 point is there.
when there is no co-sharership, how could you open the proceeding under section 8?
Yes, I was the co-sharer because a plot of land, learned judges of the view, in case of holding, there's no concept of co-sharer. That is not maintainable. But at the relevant point of time, act as an amending. So far as plot of land, the co-sharer has the right of preemption. 14 March, act as an amended with
Yes.
respect to effect.
Your case is P amendment.
PM.
Very
Case is
well.
P amendment, the judge in first post amendment.
Transfer
Only 1 point.
transfer was effected prior to amendment.
Lordship. But only 1 point is the matter, frankly speaking. The preemptor did not deposit the entire amount,
Then
but taken a plea.
now that plea will not do.
After
Honorable Apex Court is here.
That's true, my lord. I am frankly speaking, my lord, that is a defect in this on my part. I am on backfoot on that point. But fact is that he also raised the point in the plain that consideration money is 8,000, but actually it doesn't pay 45,000. So he paid before this court. If it is found that entire consideration amount is paid, I will ready to pay the balance amount.
But that you cannot say.
That is the main point, my lord. Frankly speaking, that is against me.
So should it be dismissed here and now?
So far as service is concerned, my lord.
Service is not required, you know.
Then, my lord.
It can be. Yes. What is your good name, sir?
Arup Krishna Das.
Heard Mr. Arup Krishna Das, learned counsel for the petitioner. This application challenges the judgment and decree passed by learned additional district judge, first at second court Asansol in title appeal number 43. Why title appeal?
My lord, initially it was a miscase, but the judge opined it should be a suit and converted the miscase into a suit and the title appeal.
Why? Section 8 is
Yes, my lord, it should miss case file. Learned judges say no, it should be a suit, filed a suit.
Huh.
And we also filed a second appeal before this honorable court. No, honorable court says second appeal doesn't like division application.
yes. Okay, Ghulam. Title appeal number 43 of 2001 / 7 of 2001 by the impugned judgment, learned appellate court was pleased to affirm the judgment passed by learned trial court rejecting the application under section 8 of the WBLR Act. Stop. The petitioner initiated the proceeding under section 8 of the West Bengal Land Reforms Act to exercise his right of preemption as co-sharer, but did not deposit the entire consideration money before the learned trial court. Stop. Mr. Dash, with all fairness, submits that in view of the judgment pronounced by Honorable Supreme Court on this issue, it is really difficult for the petitioner to tide over the situation. Stop. It goes without saying that mandate of Honorable Apex Court is binding on all the courts in the country. Therefore, we cannot ignore the mandate that unless entire consideration money is deposited, a proceeding under section 8 of the WBLR Act cannot be maintained. Under such circumstances, this revisional application merits no further consideration and is, should I use dismissed? Dismissed, however, without cost. Yes. গরম লাগছে না, এটা বন্ধ করে দিয়েছেন না, শীত করছে। ও জ্বর, ওই জন্য মুখোশটা এসছে, ঠিক। Oh, time is up. Yes, what is your matter? 23. We are on 20. 1, 2, 3. So come back after
হাইকোর্টে বাইরে কাটাতে হচ্ছে।
But when that matter is fixed with Mr. Ghosh, commercial suit, you are appearing.
Yes. Is anything come to Lord's mind?
Wait for the date of hearing.
So far as this matter is concerned,
yes.
Apart from the fact that suit is maintainable or not, but I have on fact placed everything before my lord and pinpoint the points I want to argue. But I have not cited the judgments. I will cite the judgment first and then go to the last and final point put forward by my lord and the question of law frame. My first point is, my lord, if you lordship allow me to say that our case is that the tenancy has been transferred in terms of a will. Our contention is that it cannot be transferred. It is, if it is transferred, attempted to be transferred, and somebody else is by virtue of that will is in possession, subtenancy on the face of it.
Yes.
Attract. To that, my lord, I am relying on 1998 7 Supreme Court cases 294.
Just give me a minute. Let
my
me
lord.
Find out the note.
Hmm. 1998 7 SCC 294.
1998 7 SCC 294.
Paragraph 2, paragraphs I will only rely. I will not trouble your lordship. Paragraphs
Tenancy
5 and
right
6.
cannot be bequeathed. 5 and 6.
5 and 6.
Paragraph 5 and 6. Yes. You for the respondent. Yes.
But this is the point I will not trouble your lordship. I have 2 paragraphs if you lordship kindly read. It is though under section 21, but I say, but it cannot be transferred. If transfer is prohibited, you are not, it is not heritable to the limited extent that it is tenant died on the pre-56 Act. The heirs who was residing with him will be entitled to have the tenancy. A third party who is not the heirs and not residing with the tenant cannot have this tenancy. Tenancy is also estate. I said this tenancy is an estate, so it only can be
inherited by the legal
by the 56 Act or now 1997 Act for a limited period of 5 years. My lord has read that, your lordship can do also paragraph 7 also. Very short paragraph. My lord পরে পড়বেন আপনি আগে ছোট করে কাবুল হয়ে যাচ্ছে Around 66.
Yes.
Now, my lord, I'm giving a prelude of my main argument so far as the other point my lord has raised. That the written statement has been filed as verified. I am the one of the partner of the partnership firm. This is the verification of the defendant. Supreme Court is saying that possession of a property can be only by 4 contingencies: landlord, owner, tenant, lessee, or trespasser. So if a defendant, if I file a suit against him and he is contesting the suit, he has to prove one of the
Status.
If you are unable to prove that, eviction is inevitable. But for that proposition, I first rely on EIR 1966 Supreme Court 735. नहीं but I will request your lordship to read 2 paragraphs, paragraph 12 and 15.
Paragraph 12.
May I read with your lordship? Turning then to the pleading and evidence in this case, there can be little doubt that the defendant knew that what he has specifically pleaded. He has admitted the title of the plaintiff in regard to the plot and set up a case as to the manner in which he spent his own money in construction of the house. The plaintiff laid evidence about the tenancy set up by him, and the defendant laid evidence about the agreement on which he relied. Both the pleas are clear and specific, and the common basis of both the pleas was that the plaintiff was the owner and the defendant was in possession by his permission. In such a case, the relationship between the parties would be either that of a landlord and tenant or that of an owner of a property and a person put into possession of it by the owner's license.
Yes.
No other alternative is logically or legitimately possible. When parties lead evidence in this case, clearly they were conscious of his position. And so when the High Court came to the conclusion that the tenancy had not been proved, but the defendant's agreement also had not been established, it clearly followed that the defendant was in possession of the suit premises by the leave and license of the plaintiff. Once the conclusion was reached, the question as to whether any relief can be granted to the plaintiff or not was a mere matter of law. And deciding the point in favor of the plaintiff, it cannot be said that any prejudice has been caused to the defendant. My lord is hearing a second appeal. Both the courts will, I say both the courts will concurrently held, though cannot give the decree on the ground that court has no jurisdiction, but concurrently held. The point for eviction has been decided by on fact concurrently. And my lord, kindly read also the paragraph 15. Mainly paragraph 12, paragraph 15 also. Which something is against me.
No.
Then my
Yes, started.
this smiling is dangerous for me.
Yesterday, I dictated one judgment in this line. Today, I will insert this as reference. Yes.
Then kindly give me the name of the land advocate so that I can earn some fees from him.
Mr. Shamol Chakraborty.
From City Court.
I don't know. He's practicing. Yes.
Paragraph 2 is my precise submission before this your lordship, my lord, that facts in this case has been proved. You are in possession. So, my lord, this judgment is squarely applicable so far this matter is concerned, that your eviction is inevitable where you are in possession. Then, my lord, it may not be, my lord, multiplying, but I will cite only another two judgments for lordship consideration. 2014, 4 Calcutta High Court notes. Page 66. Paragraphs 13 and 17. Okay. Was in minutes. My lord did not trouble you the entirety. Your lordship can come to paragraph 13. The court's view. Court has
our view. Yes.
Our view. Concluding part is 1. The tenant failed to establish the tenancy, and Anglo India could prove the ownership. The decree of eviction was the obvious consequence. There, the same thing happened. They don't know, the defendant don't know in which position they are there. They are contesting the suit.
Yes.
Those technicalities, my lord is also very vast knowledge in the trial court. Now, my lord, those elements, point of notice, those are not court considering too much. My lord, you find in the CWM there are so many judgments, but on the notice point, the court dismisses the suit. But now the Supreme Court says filing of suit is a notice. So now these technical pleas, by judicial process, I should not say totally, but it is some extent, my lord, is given a go by. My lord has seen that. Paragraph 13 to 17.
I have marked it.
Then, my lord, kindly come to 2006 and 3 Calcutta High Court notes. 3 Calcutta High Court notes, 143. Paragraph 6 and 7. National traders. That's a 2006 3 CHN judgment Diwali Joseph. Okay, one judgment, my lord, I have handed over to your lordship. My lord, just want to show your lordship 2 paragraphs.
2006.
3 CHN.
3 CHN.
Justice Bhaskar Bhattacharya is the author of the judgment.
Let me see. Everything is here. The Indian law report.
If it is not there, we have a copy.
No.
Lordship marked it, that is separate.
Yes. This is FA 461 of 2000.
National traders.
National traders versus
Kindly keep the judgment.
Yes.
Kindly come to paragraph 6 and 7. May I read with you, Lordship? The learned advocate appearing on behalf of the appellant at the first instance tried to impress upon us that the suit is not maintainable as the names of the partner were not mentioned in the cause title. But here also on the same case, I will show to you, Lordship, who has defended the case. The first point was the suit not maintainable and the name of the partners were not mentioned in the cause title. In our view, the provisions contained in the order 30 of the Code of Civil Procedure are the answer to the aforesaid question. As provided in the said provision, in case of a suit where the defendant is a partnership firm, there is no necessity of mentioning the names of the individual partners and that the suit can be brought against the name of the partnership firm. Only for this extent, my lord, I am citing this. Now I will try to answer my lord's query. The main query, since from the very beginning, my lord is asking me, and all points what I tried to argue, my lord put it on the back, how the suit is maintained.
Yes.
Now, my lord, kindly take trouble to see the plain and the written statement.
Plain and the written statement.
That is the basis.
একটু দিন না আদিত্য LCR থেকে
LCR has not come.
LCR, do you have the copy of the
handed over to my
handed over to me? দেখুন তো আসে ফাইলের মধ্যে থাকবে
because of the COVID period.
Yes, it's there. Let me see.
Plain, I will not show only the who I have been added as a defendant. I will only show that. Just formally showing, nothing. It is known to my lord. Defendant is Messrs. Bajnath, Chobe and Company. Address is 37/39 Regina Street, such and such, such and such. So this is admitted fact that we have made Messrs. Bajnath, Chobe and Company. Now, my lord, summons has been served. Summon has been served. Defendant, Messrs. Bajnath, Chobe and Company, entered evidence and filing written statement. Is my lord is having the written statement?
Yes.
But kindly come to. Kindly come to page, internal page 9 of the written statement.
Yes.
Kindly come to the verification.
Verification.
Yes.
Verification is not at page 9.
Original written statement.
Original written statement I don't have. I am having this additional written statement.
Additional is should I hand over my copy for the time being?
Right. देखिए एक तो दिन तो
मात्रा देख खुले लो पैराग्राफ 9 की ना वेरिफिकेशन ठीक I will start from the end and come to the verification. Summons served on Messrs. Bajnath Company, who is entering appearance, Subroto Das, Surottam Das Mundra, one of the partners of the defendant. Can you mark this? One of the partners of the defendant, who hereby so he admitted that the defendant partnership firm has been arranged as a party in this proceeding. Am I clear to my lord?
Yes.
Verify state that the statement made in forthcoming paragraph such and such, such and such and such. Now my submission is, I will develop that. My submission is that this Mr. Mundra, representing the estate, of Bajjanath Chaubey and the company. Either it is a proprietorship concern or it is a partnership concern, whatever it may be. The estate of Bajjanath Chaubey and company defendant has been represented by Mr. Mundra, describing himself the partner of the partnership firm. Now, my lord, when the question of law has been framed at the time of Order 41/11, defendants are not there. Defendants are not called upon. My lord has seen the question of law framed. Today, my lord, kindly allow me to ask myself whether, on the basis of the facts of this case, whether this question of law can at all be framed. Judgment point, judgment point. Sir,
You know, that is the question number 1, perhaps, if
Yes,
I am not mistaken.
this is the question. My lord, I was scolded by my learned friends all here. But my lord, the question arose in a division bench at the time of Order 41, whether the defendant should be heard or not. Justice Ashok Ganguly and the late Justice C.K. Banerjee was there. I was appearing with Mr. Bimal Chatterjee. There's tremendous hue and cry in my bar. My learned friend also against me, and Mr. Dasgupta was there, saying that no, it cannot be. Ultimately, court held no, you cannot. Defendant had no say, or the respondent has no say at the time of admission. But the same point you can agitate at the time of hearing. Substantial question of framing between the court and the appellant. Defendant has no say. That held in that judgment. But at the same time, the respondent is not debarred. I can raise this point at the time of final hearing, which I am doing now. What is the point here? The concurrent finding of fact that the defendant has been represented, taken all points in the earth to prevent eviction, because it appears from their conduct they are in possession of the property. The coin now sought to be raised. My lord will not find, I will place, my lord, the written statement, I have to place it. The point was never urged. On the contrary, they shown it to the court that they are the defendant. They are not said, they never said in the both the courts below that no, the defendant is not there. We are not defendants. The suit should fail. Whether your lordship will allow them to say this point after both the courts will put concurrent findings that the defendant has represented and taken all points. Now, my lord, kindly look to the written statement hurriedly. Verification, he has said that he is representing the partnership. Now, my lord, kindly take trouble to see the page 5. All along, they are saying the defendants. I'll kindly mark that. I thought that he may be saying defendant because of a mistake. I find all along he said defendants, means the partnership firm. Deny and dispute the statements made in paragraph 2 of the plaint. The defendants deny that one Bajjanath Chaubey, since deceased, was a tenant in his personal capacity under the plaintiff. The defendants state that Mr. Bajjanath Chaubey and company took the tenancy under the Hirak Chand such and such in respect of the suit premises long before 1929. And may I transgress a little?
Why not?
Mr. Mukherjee, there will be no fee. Virtually fee hoy na.
Oh, he is there.
I take the pleasure in listening to Mr. Vasu's argument.
And without fee. Paragraph 7. Defendants deny the dispute that the statements made in paragraph 6 of the plaint. The defendants deny that in or about May 1994, the plaintiff for first time came to know for the trustees of Bajjanath Chaubey that Bajjanath Chaubey was extinct, and there was no heirs or survivors of the said Bajanath Chobe. Then, my lord, the Bajanath Chobe sons and wife, daughter also died. The trust created by Bajanath Chobe came to an end. The defendant said that the tenancy of Messrs. Bajanath Chobe and company and not of Bajanath Chobe. So all possible points they have taken. Can it turn over? These parts they may not be very much relevant. In middle portion, at page 4, middle portion, the plaintiffs are fully aware that Bajanath Chobe created a trust, and the plaintiffs were also aware of the names of the trustees when they filed title suit number 1994-94 in the City Civil Court at Calcutta. Had the plaintiff any belief that the firm as Bajanath Chobe was extinct with the death of the Bajanath Chobe, that the plaintiff would never brought the trustee of Bajanath Chobe into the records of the title suit number such and such. Then, my lord, kindly come to paragraph 10. Bottom, my lord, the defendant said that the plaintiff filed title suit number 230 of 1991 for a declaration and injunction against the Purushottam Das Mundra and Chetan Das Mundra to the effect that the defendants are stranger, outsider, and have no right, title, and interest in respect of the suit premises. This Mundra is filing, my lord, the written statement. In that suit, the plaintiff also prayed for an injunction restraining the defendants, the said Purushottam Das Mundra and Chandra Das Mundra from entering into a suit premises. In the said suit, the plaintiff described the said Chetan Das Mundra and Subha Das Mundra as outsider and or strangers. And in the said suit, the plaintiff did not describe the said Das Mundra and Mundra as partners of Messrs. Bajanath Chobe and company. Defendant claimed leave to refer to the copy of the plaint such and such. This much. So far as the other points, my lord, in the amended deed statement, they have taken all those points of not transfer. There is no parting with possession, so no subletting. Those points has been taken in the additional deed statement. I want to establish before my lord that if I am filing a suit in the wrong defendant, then you, the person who enter appearance, need not enter appearance. What bothered you? I file a suit in the name of wrong person. Nobody is bothered. That person is not there. Even if there is a decree not binding upon them. But here what happened? I file a suit. Someone served on that address. Someone taken, enter appearance, describing as a partnership firm, and contested the suit on all possible ways, and suffered the degree in both the courts. Kindly consider whether the doctrine of representation will not apply.
Yes.
If the doctrine of representation applied, then, my lord, the substantial question of law framed by the court below, the law, my lord, cannot be framed in the air on the basis of the facts. If the facts, both the courts below concurrently held, then on the second appeal, if wrong fact, wrong, my lord, interpretation of, not interpretation, appreciation of evidence, a wrong fact has way with the court, then whether that is substantial question of law, which is not at all here. These are my submission, my lord, so far as the point which is bothering my lord, that this suit is not maintainable. Who can say this? I again submit. Can the persons who contested the suit from the trial court to appellate court never said this? The suit is not maintainable because parties are defective. Can they be allowed to make this submission? This is the question my lord has to answer.
Yes.
Now, on this, my lord, I want to cite for this 2-3 judgment for your consideration and close this chapter. So my lord is having the written statement and the additional statement both. First of all, my lord, I want to rely on EIR 1966 Supreme Court. 66 Supreme Court, I have to rely for two propositions. 792.
Yes.
But kindly come to paragraph 13. Sorry, paragraph 14. 14 to 17. I know my only read it later. Will also think for the shorten of time, kindly come to read paragraph 14 and then 16. I am borrowing the inspiration from Order 22 Rule 4. Only in case of fraud, my lord, a doctrinal representatives will apply. And 16 also. Facts are not similar. What I want to derive at, can you see if under Order 20 Rule 4, some are left out, and after bona fide search we could not get, and subsequently somebody come. I was there. Then, my lord, Supreme Court is saying, for our purpose, kindly exclude that fact that the bona fide search was there, suit was pending, or that. I am arriving at the conclusion of this, that this estate were properly represented. I file a suit in a particular name, you say I am that person, and the estate has been properly represented. If it is properly represented, then, my lord, it is immaterial to the high, at the instance of the appellant, whether I have filed a suit in the name of a wrong defendant or the right defendant. আমার এগেইনস্টে দেখার বার করছি।
Yes.
দেখছে
What else?
Anything my lord want to?
No.
Something
Now
is
my-
passing to your lordship's mind.
No, no,
I can
my.
read it.
No, now it will go to Mr. Mukherjee only, not for you.
Now, my lord, next I will not multiply, only one I will cite another. AIR 1979 Supreme Court 1393.
AIR 1979
79.
Supreme Court 1393.
My
Yes.
lord, I am traveling your lordship, my lord.
No,
I'm sorry,
it's a process
but
of
the
writing.
point my lord has read, but I have to answer in my own humble way how much I can. Kindly come
It will be on the same principle, I think.
No, it's little different. But I'm showing you lordship, paragraph 42 and 43. Only two paragraphs I will request your lordship to read. They are not in the appeal made parties. In the cross appeal, they were not made parties. After that, my lord, after the entire thing is over, complaint was that in the cross appeal there was no substitution. Then Supreme Court says you are sufficiently represented, and this and is now I want to add. If today you are made parties, you cannot say anything else what you have already said. This is the addition thing here, madam. Because you have been properly represented. It will be a futile exercise. Paragraph 42, last. Left hand side, my lord, right hand side, you will see we get that part. And 43. তোর মামলা হয়ে গেছে?
Yes.
Then Supreme Court is saying it will be a futile exercise. If today, my lord, ask me, no, this is wrong defendant you have sued, so you now sue against the partnership firm and proceed for 30 years more.
No, in your case. Now, have you finished?
No, I am not yet.
Okay, you finish then.
So, my lord, this is paragraph 43. My lord has seen that.
Yes.
Point is same, that properly represented, and here
Yes.
it will be futile exercise if you are allowed now in the cross appeal to be implemented, and then here you what more I will hear. Already you have exhausted yourself. Then, my lord, I will put that. But here my continuation of my first point, first when I start, that on the basis of the pleading, court has to form one opinion. Without pleading, my lord, nothing can be done. If lordship seen the pleading in the written statement, they are appearing, they are contesting the suit as it stands, as it is framed. My lord, I will cite, my lord, 2022, one Supreme Court cases 115. Paragraph 21. May I read with my lord? Paragraph 21. A relief can only be on the basis of the pleadings alone. Evidence is also to be passed based on such pleading. The only exception would be when the parties know each other's case very well and such a pleading is implicit in an issue. It is not. In the pleading, they have never said the issue whether suit is maintainable, it is present from. And my lord, it is also not said. Normally, my lord is very accustomed with the pleadings in the trial court. 5-6 paragraphs is no, omnibus paragraph is will deal whether it is relevant or irrelevant. That is also not here. Now, my lord, I will little transgress to my lord. Don't take me amiss if I take this submission. But why I am submitting, my lord? Civil procedure code, what it is civil procedure code? Civil procedure code based on natural justice only. Framer thought that other side will not be prejudiced. You are filing an action before the court and other side is to defend the case. He should be given proper opportunity to defend his case. Enter civil procedure code, rule, my lord, the substantive part and the procedural part, both are based on civil natural justice. When we are coming to court, against we have to first say, I am prejudiced. When I apply your lordship's code in 227, my first grievance is being aggrieved and dissatisfied with this, and my prejudice has to be put forward first. So if I'm not prejudiced, I cannot approach it. But here your lordship has to examine what prejudice the defendant has suffered, who has represented. If defendant is not suffered any prejudice, but it is in their mouth is not suit, that suit is not made.
Defendant is represented duly, no prejudice. Should I now get back to Mr. Mukherjee?
Another thing, I prompted to cite two judgments for lordship concern. What I am submitting, my lord, this judgment on the field of 226 constitutional. Where it says natural justice is a facet of constitution. If natural justice is violated, everything was. Supreme Court is saying that this theory of natural justice is not a ritual. You have to plead prejudice. Suppose today a person has not been given an opportunity of hearing and order has been passed. He can complain if he is prejudiced. If after giving the same opportunity, the same result cropped up, then violation is nothing. I want to bring that principle, my lord, in this case. Well, I will cite two judgments for lordship consideration. One is 2004 4 Supreme Court cases 281.
Hmm.
281.
Yes. Ekটু এটা দিন।
It is also under tenancy law. But on the field of 226, this course limited is a famous judgment in the other propositions. Kindly come to straight away paragraph 64. Right of hearing to a necessary party is a valuable right. Denial of such right is a serious breach of statutory procedure prescribed and violation of natural justice. In these appeals prepared by the holder of lands and some other transferees, we have found that the terms of government grant did not permit transferred land without permission of the state as grantor. Remand of case of a group of transferees who were not heard would therefore be of no legal consequence. More so, when on this legal question, all affected parties have got full opportunity of hearing before the High Court, and in this appeal before the court, rules of natural justice are to be followed for doing substantial justice and not for completing a mere ritual of hearing without possibility of any change in the decision of the case on merits. So there will be no change. What they have said, they have said. Relying on that, my lord, one short paragraph of 2011 1 Calcutta High Court notes. Author of the judgment is now in the apex court. 16. Paragraph 14. It is settled law, paragraph 14, my lord, 1-4. That rules of natural justice are to be followed for doing substantial justice and not for completing a mere ritual without possibility of any change in the decision of the case on merits. It follows that an order need not be set aside merely on the ground that the rules of ordinary partem has been breached if ultimately rehearing of the matter by the authority or body competent to hear and decide would be an exercise in futility in all probability. This is echoing the judgment of Supreme Court, but the language, I think, my lord.
Yes.
So today, my lord, if I file a suit against this partnership firm, same, there will be no change. And they have substantially represented the estate. So they, at least they are debarred from saying that the suit is not maintainable on the ground that the parties are not. That's all.
Now, Mr. Mukherjee,
My lord.
though the suit at the time of filing or at the time of inception, no person was arrayed as a defendant.
Lordship.
In view of Rule 3 of Order 1, subsequently, you assumed the role of tenant. So, according to Mr. Basu, there is no prejudice, and it's a mere technical, what should I say, breach or infraction of Rule 3. So it merits, what should I say, simply no cognizance.
Lord, I have a very short answer to what Mr. Basu says. Now, Lord, according to Mr. Basu, as I hear from his argument, Lord, he says that going by the principles of doctrine of representation, you had an opportunity to defend, and therefore you have defended, and there is no substantial prejudice first. This is his simple argument on this point, as I understand. Now, Lord, the question here is, Lord, that the provisions of Lord, the Order 30 or Order 31, these are, Lord, according to the statement made by the plaintiff itself, are required to be complied with. But these are the words in the statute which, Lord, cannot be just brushed aside to say that there is no substantial prejudice caused to my client.
Right. Admitting Order 31 has not been complied with. Even there is infraction of Order 1, Rule 3. No person has been dead. When you stepped in and you submitted the written statement, you took all defense to avoid the eviction. Now, should we give precedence to the technical breaches, or should we look forward in a holistic manner? What should be done?
Lord, I'm just trying to answer your lordship. Lord, assuming Mr. Basu's argument is not upheld or correct, then Lord, I will be saying that Lord, that even if that is so, then Lord, the learned judge's finding so far as the subtendency is concerned, Lord, that cannot be sustained at all.
Yes. Is it on the ground of sufficiency? Only on the ground of sufficiency, yes.
The decree has been passed by the appellate court, Lord, on one of that ground.
Yes.
Therefore, Lord, even if, Lord, so far as the framing of the suit is concerned, I had a defense, no doubt. Now he is trying to thwarting the defense by saying that I have poked my nose into the suit. I have filed a written statement. Therefore, I had substantial defense to take. Even then, so Lord, when somebody has not come into the picture to contend that he is a defendant, can the court come to a finding, Lord? I'm asking this question to myself to say that the defendant had subletted to third persons. The third persons are before the court. Lord, if your Lordship not allows me, Lord, 1 day's time, Lord, I can give a comprehensive reply and complete this. I will also try to distinguish, Lord, the judgment of Mr. Basu.
Suggest a date. Suggest.
Not any date, not Monday, Tuesday. It is up to your Lordship, Lord, and convenience of Mr. Basu. And it's up to your Lordship.
31st of July. Mr.
31st is a Monday and 1st is not Tuesday.
But I have concluded.
No, it's all up to you.
Lord, I leave it to your Lordship. Lord, I'm there on either of the day. Up to your Lordship.
Whenever the court suggests any day, we feel difficult. It is not well. I have seen from my career from the beginning. You suggest 1 day.
Let it be Monday, Lord, if it comments to your Lordship. Lord. Monday at 2 o'clock.
31st of July.
31st of July.
Okay. Very well. Heard Mr. Basu, learned counsel for the respondent. Let the matter be listed on 31st of July, when Mr. Mukherjee will assist the court on the point of law.
In reply, he will has a right to reply.
Absolutely. Could you please come back with brief notes on argument?
We also.
No. Fact and law, whatever. I don't mind. I will get no issue. Then 31st.
I'll give a written notes, Lord. I'll prepare to assist your Lordship.
2 p.m.
Yes, at 2 p.m. doesn't.
I'm grateful.
There is no division bench at 2 p.m. If there is division bench, then we have to.
Okay,
31st at 2 p.m.
31st at 2 p.m. Then let's see. Thank you.
I'm grateful. I'm grateful.
Not only me,
yes.
my learned friends also grateful for that matter in the morning's matter. If your Lordship can do anything.
No, give me the pleadings.
Now none is here. 34 years I am suffering. I am suffering.
Yeah. No, if the pleading is otherwise,
do something.
No. If they admit the share, I can assure you 10 days maximum.
I have not recollect correctly. All shares are not 2-3 properties. Shares are not admitted. That's the difficulty, maybe. Why not kindly do something in this matter?
Then we will direct to pronounce the judgment under Rule 3.
Rule of thumb.
Rule 3, Order 15. Let's see. Let them come back. I don't know. Both are from this profession. They know the trauma. Why they?
Grateful.
Thank you.
Much obliged.
Okay, switch off. Argate. Owner matter. Another second appeal. Oh, Calcutta.
See the number.
No, no.
13, unlucky.
I faced examination with roll number 13.
Oh.
So you can ignore it. It doesn't matter.
Then thereafter, my lord has become the judge of the High Court. So 13 is. But the issue is very short, as your lordship has on the last day. But section, your lordship has pointed out
Section 55
of the
1A. Look, in view of section 47 of the Registration Act, your deed will get the precedence over the deed of
absolutely
the appellant. But the point is, your instrument was executed first, then their deed. So, had there been a fair play, this fact would have been reflected in the recital of the deed that, look, I have already executed a deed, but for this reason, that reason, I am not going to register it. It will be registered in your favor. I am going to abort that transaction. In absence of such averment, in the light of subsection 1A,
but before going into this legal matrix, may I? This is my humble request to you. Because what I've understood, though I don't do civil matters, but I am an advocate in the military matters. Now, page 72, if you should kindly have a look to the paper, but the issues framed.
একটু paper book টা দেন
Paper book টা Joseph কে
হয়তো আচ্ছা
page 72, there are 4 issues framed by the Honorable Division Bench while admitting the appeal. Page 72. This appeal will be heard on the following substantial question of law. Whether
yes, I am on substantial question of law number 1.
Section 47.
No. Yes, section 47 is here. There is a room to dilate on this point raised by me, perhaps subject to correction. If you consider the framing of question number 1. No, you say what you want to say.
But what I'm on is, but don't take me otherwise.
No.
But it's
a debate
the
simply.
duty. It is the duty of the judge concerned, but to consider the issues which have been framed before the Honorable Division Bench. Number the point that your lordship has raised, but it doesn't figure in these 4 issues.
No, I am confining my point with reference to the question number 1. Again, I repeat.
But may I read it? May I read?
Please.
Whether both the courts below have failed to appreciate that the deed was prepared on antedated stamp papers in collusion with the pro forma or opposite party with only by giving back execution dated 8th July 2011 and 13th July 2011 to take the benefit of section 47 of the Registration Act.
Yes.
But the testimony of PWs reflects that clear picture of collusion, which both the courts below have failed to appreciate, the same or not. Now, may I read section 47?
Yes, why
Because
not?
the court, the honorable division bench, while
No.
registration act.
47 of Registration Act
Yes.
is something that fetches. No, I do have. Yes, it's with me. That fetches the benefit to your client and deprivation to the appellant.
It says time from which registered documents operate. A registered document shall operate from the time which it would have commenced to operate if no registration thereof had been required or made, and not from the
Date
time
of
of registration.
Yes.
Therefore, if I can place before your lordship that before the registration which took place, it is admitted fact that their registration is prior to my registration.
No. Your execution is prior to their execution.
Execution.
Yes, and that gives the precedence.
Absolutely. This is my case.
No, this is your case.
And section 47 is exactly on this.
There is no denial to this. But the point is
collusion.
But
may I?
Yes.
May I try to unveil the veil?
Yes.
May I try to? The collusion is what Mr. Dotto has argued before your lordship at length.
I am not on that.
No. But what I've understood. The collusion was that Bhanu had a good relation with us, and we took him to a different area, from where we have collected these stamp papers, and these are the incidents happened. So, when Bhanu was not put in the box, this was the argument made. If your lordship kindly have a look to the appellate,
sorry. I'm looking at the issue from a different angle.
Yes.
You and your client and Bhanu, they're good friends. Bhanu, that is the reason Bhanu did not discharge his obligation as laid down under section 55(1)(a) of the Transfer of Property Act.
Very good.
And there lies the seed of collusion. I am not on stamp paper purchased from 200 kilometers away, etc., not on facts.
55(1).
55(1)(a). It speaks of the seller's
seller is found to disclose to the buyer any material defect in the property or in the seller's title thereto, of which the seller is and the buyer is not aware, and which the buyer could not with ordinary care discover.
Right. Now you visualize the situation. What is their allegation? Bhanu executed my deed, say, on 24th of July 2023. Since Bhanu had friendship with Ace and Ace is interested in that property, so what they did? They purchased a stamp, antedated stamp. Bhanu executed the deed, putting the date 22nd of July. So had there been, if registration is not required, then your deed is prior in time.
Absolutely.
And is bound to get precedence. Right? So, if we take it on the face value,
absolutely,
your deed was executed at prior point of time, subsequent thereto, the deed of
True.
Mr. Dotto was executed.
True.
Now, in that event, Bhanu had the obligation to disclose to the purchaser, subsequent purchaser, that look, I executed a deed in favor of Mr. So-and-so, but that sale is not going to take place. That I am now executing the deed in favor of the subsequent purchaser. I am referring to the deed of subsequent purchaser. That was the obligation or duty on the part of Bhanu, the vendor, because it was not known to the
subsequent
purchaser. It was not registered. He had no reason to find it out. He had
from
no
registration office. True.
So,
I've understood.
absolutely, it was within the knowledge of Bhanu, which he was bound to disclose, but he did not. Why? Because he wanted to give some concession benefit to his friend. There lies the collusion. Am I clear now? This is the point.
Not another answer, as if there were deed executed earlier, Manu might have knowledge it. He should have disclosed.
Yes,
Like,
that is
therefore
what
it
I am
was
saying.
not there. Therefore, it was not there.
That is what we are
That
saying.
is what the court is saying.
Now you say why this factum should be ignored. Hanu was the best person.
True.
Who knew everything.
But may I ask?
Yes, yes, why
My
not?
client is here.
Ask him.
If your lordship remand the matter back to the trial court, then whether Bhanu is alive or not.
I can put it in the other way, that if there was deed executed earlier, Bhanu did it. Bhanu had knowledge. My submission is that there was no deed, that's why Bhanu didn't disclose. There was no ideal execution, that's why Bhanu didn't disclose. From our deed, it will appear that
Bhanu is dead.
now, but therefore, kindly see, Lord, other things, other materials are also there. Lord, the property purchased by us at a consideration of 2 lakh.
No, I am not on collusion. Now Bhanu is no longer there.
Yes. Lord, therefore, from the registered deed, registered document that is executed in our favor, it will appear that what Bhanu has said, kindly see, from the deed itself, I am reading. What we've done here.
Did he receive anything more than that you offered or you paid?
Lord, kindly see. করিয়া দিয়া আমি লিখিয়া দিতেছি, অঙ্গীকার করতেছি, অদ্য হইতে আমি মাই বাড়ি সংক্রামে সম্পূর্ণরূপে সত্যচ্যুত হইলাম। আপনি অদ্য হইতে আমার উক্ত সত্যে সত্যবতী হইয়া আমার নাম খারিজে আপনার নিজ নাম
15th of July.
ধার্য খাজনা বর্তমান সন হইতে মালিক ফেরস্তায় আদায় দিয়া ইত্যাদি বাড়ি সংক্রামে
15th July.
15th July.
It is. Lord, kindly see this. Here also says, আমি মাই ওয়ারি সংক্রামের সকল অস্থাবর সম্পত্তি নিলামের দ্বারা
No, because that is there, this question is.
Lord, yes, প্রকাশ থাকে যে
I am not in dispute.
প্রকাশ থাকে যে কাইন্ডলি সিমিলার প্রকাশ হইল যে আমি মাই ওয়ারি সংক্রামে আইন চাষিব অত্র দলিলের সমূহ সম্পত্তি আমি প্রকাশ থাকে যে উক্ত বিকৃত সম্পত্তি আমি ইতিপূর্বে অন্য কাকেও দায় সংযোগ হস্তান্তর করি নাই। This is very relevant. Lord, if there was there that
it was never your point, Mr. Ghosh. You are now deriving inspiration.
Absolutely. Lord, he is developing his case from the question that your lordship has put to me.
Question has been formulated. The question number 1, it includes everything.
Very well. Now let's listen to Mr. Bhattacharya.
But what I have placed, But I cannot develop the case from this.
No, you are the plaintiff. No, you are the
I
defendant.
was the plaintiff.
You are the defendant.
Yes, I was-
Possession is with you.
Yeah, no recovery of possession has been paid.
Now, if your lordship sees,
Let the
Baba.
বলুন না দেখো আমি জানি আপনি বুঝুন
আমি আপনাকে দেখছি না আমি আপনার থেকে শিখবো Let page 52 of the paper book.
Yes, page 52.
Points for determination.
Whether
the judgment and decree passed by the London Civil Judge Senior Division so is sustainable or not. But a decision with reasons, if your lordship kindly, but I have on the last day, but argued that page 54, appellant contended, but here, the appellant contended that the deeds of plaintiff number 1 and 2 are produced, produce of collusion. Produce of pollution for the reason that they collected stamp papers for places other than Bhupati Nagar, namely Narayangarh, Paschim Medinipur and Ramnagar, on the false excuse that these stamps were not available with the stamp vendor of Bhupati Nagar. This long delay in between execution and registration implies that the deed was antedated. Several causes like illness remaining out of station have been assigned to such delay, but none have been substantiated. But this point was never taken before the court below, which my learned friend Mr. Ghosh and Mr. Dotto just now was arguing and developing the point. But this was the consideration before the appellate court, first appellate court. My lord, kindly consider.
No.
But in the while admitting the order 41 application, but the court, the Honorable High Court has framed issues. This point was never argued before the court below. And secondly, he also point out that Bhanu purchased 1 decimal of land in Bhagwanpur, PS from 1 at so PM on 15th of July 2011 from 1 Nirmalendu Shashmal by going to the office of the registrar, but sold the same along with the suit property to the appellant on the same day. And the concerned deed, exhibit number 1, was presented for registration at 5:20 PM. But at 5:20 PM, may I put this question to myself, does any government office open or remain open at 5:20 PM? I don't know. On 15th of
even at 9 PM up to 9 PM it is.
Well, this is not the way. This is not the way. Mr. Ghosh is very senior.
Why?
No.
Have some patience. Let's maintain the decorum. We are in debate.
When he argued, I kept mum.
Now, I should not say so, but if I am permitted to say so.
Yes, my lord, yes. But we take permission from your lordship.
No, because we are on live streaming.
Yes.
So something which, anyway.
Now, sold on on 15th of July at the private residence of defendant number 2 on commission, avoiding going to the office of the registrar at Bhupati Nagar. The registration was completed on 18th of July 2011, but the draft for payment for the deficit court fee was ready on 15th of July. He exclaimed, if there was no collusion between the defendant number 1, defendant number 2, and the said Nirmalendu Shashmal, it is not possible to purchase the said 1 decimal of land in Bhagwanpur jurisdiction to attract the jurisdiction of Bhagwanpur to get the deed registered at Bhagwanpur by avoiding Bhupati Nagar. The appellants were aware that the deed of the plaintiff and
That's why they, with a view to conceal and suppress their deeds, got the deed executed and registered in a clandestine manner. They were so cunning that they got the bank draft for payment of the requisite stamp duty ready on 15th of July itself. Then I have gone through. Then the court found page 57, the allegation of collusion, middle portion here. Here, page 57. Because
we have seen that yesterday, perhaps. Page
Yes.
57, yes.
But I have placed it before your lordship. The word which
The
is
allegation
troubling
of
your lordship is
collusion,
collusion.
Yes.
Now, I am on collusion. The allegation of collusion to be substantiated requires some concrete proof with strong indication. It is true that direct evidence of collusion is not available, but strong circumstantial evidence is required. It is a fact that the appellant during trial has not produced any ocular or documentary evidence to show that the stamp papers of Exhibit 2 and 3 were antedated. Stamp papers can be collected from any licensed stamp vendor for preparation of deed. Merely because the stamp papers were collected from elsewhere, the deed cannot be thrown away. The contention of the appellant that the deed of plaintiff was prepared on antedated stamp paper is not substantiated. The court held that. Upon a side-by-side look into Exhibit 2 and 3 and Exhibit A, ignoring the fact date of their execution, it is not decipherable as to which one of was executed earlier. So there is no internal indication in the document itself that Exhibit A was executed prior to Exhibit B and 3, Exhibit 2 and 3. As seen above, there is no definite oral or documentary proof that indicates Exhibit A was executed prior to Exhibit 2 and 3.
Your deed was executed prior to that, because we will consider it from the face of the document.
Absolutely. But the last point is left is collusion. But how the learned court below has dealt with the collusion, kindly have a look.
But learned trial court did not consider the point I am raising. That is the whole difficulty.
But the difficulty I cannot overcome. And Bhanu is no more in the world.
Yes. Now the question is about the possession of your client.
Yes.
That is another vital ingredient. Do you have the deposition? How that possession issue has been?
Kindly see the last line. Last line of the cross-examination of the deed of.
Where is that?
He has said that.
Where is that cross-examination, deposition? Have you incorporated it in the paper book?
No, it is not. No. Second appeal, paper, it is not.
Not there. So give it to me.
Madam, kindly see. Last line.
DW1, I have given it A1.
Why DW1? It is PW. First you show me how PW was confronted with. Cross-examination.
Yes. Bro, kindly see the last line. They have suggested that you have taken possession forcibly. I am admission that is possession. We are in possession. Last line of the cross-examination. DW.
They are in possession. You are in possession.
No, I am in possession. They are admitting. No, kindly take.
No, it is not a fact that forcibly and illegally I have possessed the suit property.
Yes. Lord, now, Lord, it is fact that we are in possession. It is admission here also.
No. Admission here also will not do. It should come from the record.
Record it appears that they are suggesting that you have taken possession, but that is forcibly and
Suggestion
illegal.
doesn't have any probative value.
Illegal.
What is the positive evidence?
আমাদের টিপ দাও টিপ তো দাও নি
No. Did you cross-examine the PW1?
Yes.
What is the outcome of that cross-examination?
Nothing. There is nothing.
Then how did you substantiate your position?
Lord, your lordship, can you see whether he is substantiated? We have immediately after possession we have recorded our names in the record of right, but they have not done. We are in possession, that will appear from the record of right, that is exhibited.
Exhibit?
Lord, and they are Lord,
Exhibit? ROR exhibit?
ROR exhibit. Lord, ROR exhibit C.
C.
And Lord, while they are disturbing possession, we approach the High Court. High Court also protected us our possession in writ petition. Kindly see Lord, exhibit C.
Exhibit C, certified copy of LRR1. Now, Mr. Bhattacharya, do you have that specific relief act with you?
But I have Registration Act and Transfer of Property.
No, if you can download the provision, you see there is a proviso to section 34. Let me see if I can lend a book. Hey, Aditya, আমাদের এখানে আছে না specific relief act? এখানে কে বসে আছে? এটা স্পেসিফিক রিলিফ একটা ডাউনলোড করুন না, খালি 34টা দিন তাহলেই হবে।
Specific relief act 34.
Yes. The point is, when you are not in possession, you are under obligation to seek for consequential relief. So there should have been a prayer for recovery of possession to Mr. Bhattacharya, not to me.
I will propose.
দিয়ে দিন আর প্রিন্ট আউট নিয়ে নিন, ওনাকে দিন বা আমাকে দিন। Now if you have you gone through the provision or these into physical copy test?
এই তো ওইটা পেয়েছো? শুদ্ধতার অফ সেক্স স্বপনের অফ সেক্স স্বপনের
In your written statement, Mr. Ghosh, you did not disclose your position.
Yes.
Did you disclose?
Yes.
I don't find it.
No, no.
Read for us where you have stated.
Position. But Dolly clearly indicates the deed that have been put in possession.
No, no, every deed contains that statement. সত্য ছাড়িলাম আর আপনার দখল লইলাম. That is a
Lord, yes. Is a page, this is paragraph 21.
page.
প্রস্তুতায় বিবাদিনী ক্রয় করিতে সমতায় মোট পণ্য মূল্য এত টাকা স্থিরীকৃত করিয়া 2 নম্বর বিবাদিনীর নিকট হইতে 1 নম্বর বাদীর উপস্থিতিতে সাক্ষীগণের সাক্ষাতে গত 1 তারিখে 15/7/11 তারিখে এত টাকা গ্রহণ করিয়া বিবাদিনী বরাবর এক খণ্ড
প্যারাগ্রাফ
সত্য দখল ত্যাগ করিল করে
প্যারাগ্রাফ
Lord, that is paragraph 10 at page
2019.
Yes, ma'am, maybe. Eighth line from top.
Now, Mr. Bhattacharya, the difficulty is both the parties are claiming possession over the suit property.
But only for once.
Yes, yes.
My client doesn't have the WS with.
You just go through it.
Gone through.
No, when there is parties are at issue over possession. Both are claiming possession. Learned trial court ought to have framed the issue. Issue should have been there regarding possession. Trial court did not frame any such issue. How could he say that possession is with the plaintiff?
That is why I see nowhere discussion, nothing else. Simply said that he is in possession. He is in possession. But admittedly, they have suggested. We are in the chief at paragraph 5. We have stated that I am in possession, and what they have given a suggestion in the last line. That
Suggestion will not do anything.
Lord, they
It's
have-
mere
that's why, Lord-
suggestion. It has got no
Lord,
probative value.
kindly see,
No,
Lord.
since I am not on suggestion,
No,
there
no.
is a document from the side of defendant,
Defend.
LRR, which is prima facie indication of his possession over the suit property. Now, learned trial court did not frame any issue as to the possession. Decreed the suit, declaring that he is in, he has the right title interest as well as possession.
But
So
I don't have
inherently-
the registered document with me. Sorry, I did not muted the property. I did not get the property registered, muted in my.
So you are not in possession. So if you are not in possession, then section 34 creates an impediment, further impediment. If you read it, explanation just before that, provided that no court shall make any such declaration where the plaintiff, being able to seek further relief than a mere declaration of title, omits to do so. So law says if you are not in possession, you are under obligation to pray for recovery of possession. If you don't, you cannot get any declaration. Now it reflects two things. People are losing interest in civil laws. A place like Contai, how come the lawyers, they don't know the fundamentals?
It is something not expected at all. Lord, in the page of-
Places like Contai, Diamond Harbour, these are the breeding grounds of civil disputes.
Lord, Trent also, they have admitted that I am in possession because he has stated that when he was giving the aisle, this month, aisle, your lordship knows,
yes,
we resisted. That is the cause of action. But kindly see their Trent also, they have admitted. And in spite of that, no recovery of possession has been paid. Yes, paragraph 6. বাদীগণ নালিশি কতফসিল সম্পত্তি আইল দ্বারা ঘিরিবার কালে 1 নম্বর বিবাদী নালিশি কতফসিল সম্পর্কে কি এক কবলার কথা প্রকাশে এবং নালিশি তফসিল সম্পত্তিতে বাদীগণের সত্য অস্বীকারে বেদখলের ধমক দেয়।
বেদখলের
বেদখল আইল করতে গেল আই রেজিস্টেড বেদখল।
And fair portion, my lord, I have seen.
But then 7 is important. What your lordship has said. নালিশি তপশিল কর সম্পত্তিতে বাদীগণের রাইট টাইটেল ইন্টারেস্ট পজিশন রইয়াছে। But I want to only add only one few lines.
Yes.
But if the property is registered in my name and I get the property mutated in my name, it does not mean that I am in possession.
Fine, but it carries a presumptive value that you are in possession. You are to rebut that presumption. That's the law.
True.
How to rebut it, how it has been rebutted. Even there is no issue framed by the trial court.
Not a single question has been asked regarding the record of right, which is exhibited on it.
As well, they have mutated the property in their name. But I could not able to mute it.
No, you cannot mute it. But
the same question I asked my client who is present in court, but why you have not muted? Now, he said that as they have muted the property in their name, but he could not, but he went there. Could not mute the property.
Still, when he is having a title deed in his favor, he had the right to raise his objection.
Absolutely, but
he didn't do that.
I'm also learning.
No, it's not question of learning.
I can say something, Lord.
Yes.
It is outside court. Your lordship can see it is a speculation that if he can win the case, then the consideration money will be divided. That is what I understand. I have heard. This is fact. He has not purchased property. One and understanding of fund with understanding of Bhanu, but Bhanu is no longer.
No, why? Why? Bhanu having taken money from you, what's the point? He must have shown his interest to purchase the property. Maybe Bhanu gave some concession to this gentleman. That may happen, but I don't think without. Anyway,
that has been done.
let's not speculate and surmise. What's the point?
Lord, we have purchased 2,32,000. They have purchased 1,99,000. And Lord, kindly see, for 54 decimals of land, valuation is 99,000 and 21.5 decimal is 1 lakh. 2 deeds. There are so many anomalies and improbability.
But let me close my argument. I leave it to your lordship. I cannot improve my case from here.
No, that's true. Very well. Hi, Saurabh Babu. Look. Heard Mr. Bhattacharya, learned counsel for the respondent. Hearing is concluded. Reserve for judgment. Mr. Ghosh, may I keep this?
Yes.
এইটা একটুখানি ভেতরে পাঠাবেন আর সপ্তাংশ বাসু আর্গুমেন্ট করলেন না যে জাজমেন্ট গুলো একটু দেবেন ওইটা দুটো জাজমেন্ট আমার একটু দিন আমি এখনই বেছে নিচ্ছি
We are really grateful to your lordship that Malad has supplied this.
No, the alarming situation is these are the fundamentals and advocates of Contai. They didn't find importance in that. It indicates people are showing more interest in
Criminal matters.
matters.
And I can tell you, lordship, for last 23 years, I am in this profession. But every junior comes to me, sir, আপনি কি criminal করেন? না. What? না, আমি criminal advocate.
While dealing with
Same thing.
But at first, I have taken note, no prayer under the recovery of police.
अरे ছেড়ে দিন না ভাই।
No. But these are basic, as your lordship pointed out.
This is unfortunate.
We have learned from Justice Jyotirmay Bhattacharya, thereafter Hiranmay Bhattacharya. Then
They are doing civil matters.
Yes, the civil serista.
Now
From Mr.
I am working with Justice Bhattacharya's son, Shaunak.
Shaunak, yes.
Shaunak is a very good very good advocate in civil matters.
Well, I had opportunity to contest Virupakha Bhattacharya with my senior at Parvipur. Virupakha Bhattacharya is Lord grandfather of Jyotirmay Bhattacharya and father of Sadhan Bhattacharya. For several generations they are lawyers. My senior was Mr. Rishikesh Ganguly, who was in the judicial service. He retired in 1959 and practiced up to 1989.
Before we were born.
And Lord,
Grateful.
after retirement, he practiced Lord up to 89 before this honorable.
Well, with your lordship's kind permission, shall we?
Yes, yes, thank you.
Great.
এইটা আদিত্য এই এখানে থাক।
With my lord's kindly.
Yes, thank you. এইটা আমার ওখানে গেলে হারিয়ে যাওয়ার হাই চান্স। কিছু করতে হবে না, আপনি এই একটা পাতার ছবি তুলুন একটু আপনার ফোনে, আর 12 নম্বর প্যারাগ্রাফটার ছবি তুলুন, করে আপনি একটু সোমনাথকে পাঠিয়ে দিন তাহলে। She has been waiting since morning. Yes, madam. What is your matter? Item number 23. 23 তে ডাকুন, বসে আছেন। I was about to dismiss it yesterday, no?
Yes, my lord.
You stopped me. Why?
My lord, preemptive in a suit for preemption application is the petitioner before your lordship. The preemptor opposite party filed this application for preemption on the ground that whether the entire share or a portion of the share has been sold or not. The point of issue was in the trial court that the trial court decreed the suit in favor of the preemptor, that on the ground that since I could not produce any specific partition deed, that's why trial court disbelieved my case and decreed in favor of the preemptor opposite party, my lord. Against that decree, my lord, I preferred an appeal. Appeal court affirmed this judgment of the trial court, my lord. And against that judgment and decree in the appeal court, my lord, I preferred this instant application, my lord.
Okay.
My lord, kindly see that during the pendency of this application, my lord, in the year the civil revisional application has filed in the year 2011. In the year 2019, my lord, I filed an application, my lord, application for taking note of subsequent events, my lord, that is can number 7726 of 2019.
Yes.
That application is relating to, my lord, that during pendency of the revisional application, the preemptor has sold his entire share in favor of third party, my lord. Kindly see the annexure. Page 41, my lord. Page 11. Page 11 of the CAN application 7726. Page 11. That is registered deed. Vikreta Rajbihari Banerjee. That is the preemptor. Preemptor opposite party in this application has sold his entire impugned property which is impugned in this preemption application, my lord, in favor of one Pompa Misro. My respectful submission before your lordship that since the entire property has been sold, the interest has been lost and the application has been dismissed. The suit has been dismissed, out of which the present revisional application is arises. Accordingly, the application should be dismissed, my lord. Preemption application. Since the entire interest has been vested in favor of the third party, my lord. Compromise.
So you were representing this Rajbihari Banerjee.
No. Rajbihari Banerjee is the preemptor, opposite party. I am appearing for the preempting.
So you filed an application under Section 8.
No, I filed this application and for taking notes of subsequent steps.
No.
I have filed this application.
Who filed the application under Section 8?
Opposite party.
Opposite party.
Opposite party.
Opposite party filed an application. You were opposing the same.
Yeah, I am. I am the preempting.
Now, opposite party being the vendor, subsequent vendor, Rajbihari Banerjee is the opposite
party.
Now, who filed the application?
I have filed this application 7726.
No, I'm not on that. Rajbihari Banerjee filed an application under Section 8, challenging your transfer.
And to preempt the sale of
Yes.
my sale.
To preempt the sale in your favor. You purchased the property.
I purchased subsequently in the year 2003. The Rajbihari Banerjee opposite party filed the application for preemption to preempt that sale.
Yes. So you have purchased the property.
Yes.
And Rajbihari wanted to preempt that.
I want to preempt.
Now Rajbihari transferred his share.
Yes, his share.
Therefore, Pompa Mishra, but the difficulty is
Since the opposite
what
party
is the yes, I understand.
that is registered deed, my lord. Since yes, transferred is entire interest in favor of third party, that's why the application is
So
not
what was the ground taken by Rajbihari?
on the ground of co-sharership and vicinage.
Co-sharership and vicinage.
I took the defense that I have purchased the entire share, demarcated entire share.
That
Their allegation is on the ground of
No,
co-sharership.
this entire share theory is now under challenge under consideration rather before the
Yes, sir.
special bench,
Yes.
before the larger bench.
Special bench.
So
Since the interest has been vested third party, then the application is
no
not. reasonable.
interest of Rajbihari since vested, yes. So now if I dispose of your application, this is your application.
Yes.
Shekhar Mukherjee, you are representing Shekhar Mukherjee. You have challenged the judgment.
Yes.
Now, if I dispose of your application,
Yes.
what would happen? The judgment will be there against you. I have to dispose it off on merit.
Yes. Since the interest has been my respectful submission before your lordship, since the entire interest has been vested, he is not interested in that property. He filed this application to seeking to preempt the sale of mine. Since that his allegation was that it was the vicinage on the ground and co-sharership. She has interest, his entire interest has been vested third party. Third party is not coming in front of me. Since he has sold the entire property, the application is not made. My respectful submission is he's not in existence of that property. Is not physical possession is not. He is not acquired or possessing the physical possession of the property. How the interest has been exist, my lord, in favor of the opposite party, my lord.
Then, yes, then the other difficult part is that natural justice. We do not know it's your application. Then you have to serve.
Yes.
You have to draw the attention of Rajbihari Banerjee.
Yes.
The petition you have filed.
Yes.
Let him respond.
Yes.
Hmm?
Yes. Kindly fix a date, my lord. Otherwise, we
Suggest a date. Suggest a date. No issue. I will fix the date.
within week.
Within week.
Yes, my lord. Kindly fix
Service
it.
will be completed.
Yes, my lord.
I don't think so. Today is 25th, you leave the 26th. If you can send it tomorrow by post, 26th, then very well. I may fix it on 10th,
Yes, madam.
10th or 11th.
Yes, madam.
আসুন তো Shaunak Bhattacharya, he appeared.
Well, I have filed a no objection
Oh,
certificate.
he was there.
On 23rd September 2021.
So you were there? এটা আজকে করার ছিল, এটা হিয়ারিং হয়ে গেছে না, জাজমেন্ট দেওয়ার ছিল আজকে বিকেলে বলেছিলাম তো। ও ঠিক, হ্যাঁ দিয়ে দিচ্ছি। What is your good name, madam?
Monali Vishwas.
Monali.
Monali Vishwas.
Monali.
Yes, madam.
Okay. Third, Miss Monali Vishwas, learned counsel for the petitioner, who by filing a petition being CAN 7726 of 2019 has brought on record the fact that subsequent to the filing of this application, Raj Bihari Banerjee, the opposite party preemptor, transferred his entire share to a stranger, to strangers, to the property in suit, Pampa Mishra and Somnath Ghotok. Stop. Somnath Ghotok. The petitioner is directed to serve copy of the petition upon the opposite party let the matter be posted on 10th of August under the heading hearing.
Well, both application, revisional application along with this application.
No, revisional
application has been served, but no affidavit of service is lying in the record, my lord. That's why I am.
Yes.
saying-
Since there is no indication that application for revisional application, a copy of revisional application was served upon the opposite party, the petitioner is to serve both the copy of the revisional application as well as the copy of the CAN numbers ones. ওইটা তাহলে প্রথমটা বাদ দিয়ে ওইভাবে করে দেন।
Deeply obvious.
হ্যাঁ, এইটা আসুন তো একটুখানি করে হ্যাঁ ফুল করে দিন, কি হবে? কোনটা? ওইগুলো সমস্ত বার করে নি ব্যাক রিপোর্ট আছে
What is this?
আছে
Where is your affidavit?
affidavit no my lord
No, matter is coming after 9 years.
my lord
No, my lord will not do. You notify,
as per your
notify the opposite party. Take down.
I have already served before mentioning.
Oh, it was dismissed for default.
Yes, ma'am. And in the meantime, OP number.
Where is your prayer for restoration?
Huh?
Where is your prayer for restoration?
Restoration.
You have not filed. Sir, there is someone contesting the petition. They have the right to get notified.
My lord, I have served.
Served upon whom?
OP.
There is no indication.
OP number.
You mentioned the matter to be listed. Now it appears that the matter is appearing after 9 years. How could you take your adversary by surprise?
My lord,
You have to notify them.
my lord directed me to serve copy of revisional.
Have you served?
Already I have notified.
Where is that affidavit?
Affidavit already, affidavit, no? With letter and track report and registry.
You have to
File my lord.
You have to submit.
At the time of mentioning, with mentioning slip on 12th of.
আরে তো affidavit of service file করেছেন না?
Affidavit service, I submit. ওইটা সে mentioning slip এর আগে সে mention.
This is
already-
sufficient for inclusion. Now I am giving you direction. You serve the copy of the petition.
Yes, my lord.
You serve and come back.
Yes, my lord. With revisional application.
Yes,
Yes, my lord.
revisional application, restoration application.
And one, my lord, expunge petition. The expunge application.
Whatever you invite the court to look at, you have to serve upon them.
Yes, my lord.
What is your good name, sir?
Anirban Mujumdar.
Anirban Mojumdar. Yes. Heard Mr. Mojumdar, learned counsel for the petitioner. The petitioner is directed to serve the copy of the applications upon the opposite party by registered post. Let the matter be listed on 4th of August. There is another matter on 4th of August.
Yes, ma'am.
Let the matter be listed on 4th of August. On the adjourned date, affidavit of service is to be filed. That's it. Thank you.